The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I am Judge Rubin. I'm joined today by Judges Massing and D'Angelo. We are sitting by video conference today due to some COVID illnesses, and we appreciate the assistance of the clerk's office and of counsel for the parties in assisting us in altering the argument schedule to be able to do this by video conference. We will be hearing 5 cases this morning. The rules of argument are the same here as they are in our courtroom, which is to say 15 minutes per side and no rebuttal. The first matter we will be hearing is number 22-210, Commonwealth versus Scordino. And we will hear first from you, Attorney Yashulis. I should say a clock will appear in the rectangle that now shows our the seal of the court. And that will alert you as to the time. It doesn't turn yellow like in a courtroom, but it'll be right there on your screen, so it will be hard to miss.
Thank you. Good morning. Good morning, Your Honors. Laurie Schulis for Ms. Scordino. Today, this case really represents a situation where the Commonwealth has failed to present sufficient evidence to support Ms. Scordino's conviction for uttering a false check. This court, as well as the SJC, has given us guidance as to what is sufficient evidence, circumstantial evidence for knowledge and intent when it comes to the crime of uttering. And the underlying theme in these cases, as you will see from the Ms. Scordino's brief, is that you can't just simply say because someone has presented a check to their bank with no other indicia to demonstrate any sort of knowledge or intent that that's enough. When we look at cases that this court and the SJC has decided, we see there has to be more, a plus factor, if you will. For example, in Commonwealth v. O'Neill, there was some sort of consciousness of guilt to demonstrate that knowledge and intent. In the Cronin case, there the defendant cashed multiple checks at a bank where she wasn't a customer, or he wasn't a customer, and identified himself as someone else, but had the same name. In the Burrell case, that defendant cashed 3 checks at 3 different banks, similar as in the Croker case, where they cashed 3 different checks at 3 different branches over 3 days.
So in those cases, did the person who supposedly wrote the check testify, I never wrote the check, I never gave anybody the checkbook, and I don't know the recipient?
Your Honors, I don't remember the specific facts. What I do remember is what was enough, that what the court found sufficient. In this case, if you're referring to Ms. Scordino's case, yes, the victim did testify that she did. Ms. Adams testified she didn't know the defendant and didn't write the check.
I mean, but that would be important to know, right? If in those cases that you compare it to, there was evidence similar to that here, where the person who supposedly wrote the check said, I didn't write the check and I don't know the person who cashed it.
That is significant, but it's not the only thing, because that's coming from the victim's standpoint. It doesn't really shed light on the defendant's knowledge or Ms. Scordino's knowledge. That really shed light on, only one aspect of the evidence that's sufficient here. The other aspect is you have to show something that the defendant did. What did he or she do to demonstrate knowledge or intent?
Well, but if the jury believed the statement of the person whose check it was, I don't know this person who cashed my check and to whom my check is apparently written out. I don't know who that is. Can't we then infer that if they find that's true, then can't we infer that the defendant also did not know the person who wrote the check? And isn't cashing a check from someone you don't know signed by that person? Why can't that support knowledge that you're not supposed to do it? It's not your check, it wasn't actually made out to you by this stranger. It's for hundreds of dollars. What's
So-
wrong with that inference?
So that just isn't enough. And so we'll look at the Pacheco case, right? So in that case, I cite that as well as the Commonwealth. And in that case, you have someone who's writing out checks from a stranger's checkbooks who they don't know. In fact, the stranger confronts the defendant, says, hey, that's my checkbook. And the defendant there says, yeah, I know. But what's interesting in the Pacheco case is there's another person who attempts to cash a check that's written from that checkbook. And that's Mr. Pacheco's attorney. Mr. Pacheco's attorney receives a check from Mr. Pacheco, who's written out from the stranger's checkbook. And it's an attorney. And when that attorney goes, and it was for legal services that Mr. Pacheco had hired that attorney for. And when that attorney goes to cash a check, there's a hold on the account. And when that attorney's asked, she says, well, I commonly receive checks from, my, other people for legal services for my clients.
But
So
that's a check. That's a check that was endorsed, pay to the order of. That is, the check was made out to the client and then transferred to the lawyer.
Actually, the check, Mr. Pacheco wrote out the check. He left the two portion blank. I believe the attorney filled that in, but it was signed by someone purportedly to be the check holder. And when the attorney went to cash it, she couldn't cash it. And in the Pacheco case, it's in my brief at the specific languages on page 68 in my brief, it's in the addendum. She says, well, I commonly receive checks by third parties for legal services from my clients' relatives or girlfriends. So that's interesting because that tells us that it's just not enough to go cash a check.
But that means
Counsel-
but that means that the attorney did not know that the signer of the check was someone unknown to the person who handed him the check.
Correct. And that could be the same scenario here. So we don't know. So what we do know actually is that Ms. Adams didn't have exclusive control over her checkbooks. There were 3 other people living in the house, and there's a trustee on the account that we never hear from. So
Wait, no. This particular check I thought was not a trustee check. It just had the name of the victim, right?
So it has the name of the victim, but the actual account, it's written on account. The account has 2 checkbooks, right? So there's 2 checkbooks associated with the account. It's a trust account, and there's 2 trustees. One of them being Miss Adams and one of them being John Adams.
And the checks are printed just with the name of Ms. Adams?
This particular check was, and the check written out, the 2 checks written out to Carl Darcy had both trustees' names on it, but the account is one trust account and has 2 checkbooks associated with it.
Counsel, the Commonwealth never presented any evidence of who actually did sign the check. Is that correct? They only presented evidence that Ms. Adams did not sign the check. Isn't that right?
That is correct. And actually, there's no evidence presented to show that Ms. Scordino was unaware that Ms. Adams hadn't signed the check. In fact, they dismissed the forgery count, and the larceny count was not proven. It survived a motion for required finding of not guilty. So there's no evidence at all on how Ms. Scordino received this check or that she had any knowledge that it was fraudulent. And that's where the leap has to come in with that circumstantial evidence. There has to be a leap here because there's just not enough evidence.
Did the Commonwealth, to your knowledge, ever in the discovery phase seek a writing exemplar from your client to try to match it up to the check to see if it matched your client's signature or or I know it wasn't really a co-defendant, but the other person who may have been involved?
What I do know, there was cross-examination, and I believe that that question was asked on cross-examination, and the answer was no, that there was no attempt to do a handwriting exemplar at all in this case. And
so there was no evidence. I think your argument comes down to, partially at least, that there's no evidence that your client knew that it wasn't Ms. Adams' signature on the check, or that perhaps Ms. Adams gave her the check. We just don't know how that all occurred. Is that right?
That is part of my argument. In addition to that, I think it's interesting that Miss Adams testifies that nobody has access to these checkbooks, yet someone has access to them, and someone took them, and someone forged them. But there's no evidence that Ms. Scordino knew of that. There's absolutely no evidence there. And that's where that leap or conjecture comes in, because you have to take that leap in order to say, well, Ms. Scordino didn't know the victim. Well, the victim says she doesn't know Ms. Scordino. So therefore, Ms. Scordino must know that the check is forged. That takes a leap. That takes an unfair inference to get there.
Do you think that by us not making that leap, by not finding that inference that some of the cases show, we are changing the law in some way? Or do you think there's just that missing factor that you were talking about earlier?
It's not a change in the law. There's just not enough here. The standard is proof beyond a reasonable doubt, shown through circumstantial evidence. And you just don't get there here. You get Ms. Scordino cashing a check at her bank using her own ID. No other indicia, noted in all these other cases that I cite, talking about, even altering a check or anything like that to get you to Ms. Scordino cashing a check, and she knows that it's fraudulent. So it's not changing the law. It's following the law, actually. It is actually following the case and the statute on what's required to be sufficient circumstantial evidence. And in this case, there just isn't enough. It's not a change in the law. It's following the law. This case is just not enough. I mean, you have to make this leap that Miss Adams doesn't know Miss Scordino. She goes to cash a check, therefore she must know. She has to know it's fraudulent. There's no connection between that. There's other people who had access to the checks who could have taken it. And as trial counsel argues in her closing argument on the trial transcript, page 44, she argues, there's a lot of people who could have taken this check and signed it and given it to Miss Scordino. We just are missing that connection. And in order to get there, the fact finder has to make this leap. They don't know each other, so she must know it's forged. They don't know each other. It must be forged. Kind of like the attorney in Pacheco.
Well, the attorney in Pacheco isn't the defendant.
Correct, but
I've just been looking at Pacheco in the appendix, and the attorney isn't the defendant. And so we don't know whether that attorney, we sort of presume the attorney couldn't have been convicted of uttering.
Fair. That's fair, but I still think you can envision a scenario where someone receives a check from a stranger, doesn't know that person, for third-party services to which we do not know. There's just not enough evidence. So if I go to cash a check from somebody I don't know, am I per se guilty of uttering because I don't know that person?
Well, counsel, is there any, I guess I'm going to twist what you just said a little bit. There's no evidence that the Commonwealth presented that the defendant didn't know he got the check from Ms. Adams. For all we know, what happened was a person who purported to be Ms. Adams. That's what I mean. We don't know that based on the evidence. Is that accurate?
That is accurate. And trial counsel did argue that in closing argument. She could have received this check from somebody who said they were Ms. Adams.
And the
we
burden,
don't know. That's the problem.
The burden is on the Commonwealth. She doesn't have to come in and say, I got this for services I rendered to a third party. They just had this check and that's what they paid me with. And what do I know? She doesn't have to say that. Although I'm trying to figure out how you prove uttering if that's the law. Well, I'll ask your opposing counsel. This question is really more for him.
Correct. So, so I do cite to a lot of cases here that talk about these plus factors regarding what you need to show. And Ms. Scordino didn't display any of those. The check wasn't altered. She didn't have multiple checks. She went into her own bank with her own name and her own ID. And that just isn't enough to prove uttering. You need more. You need to show something else in order to prove that she committed the crime of uttering.
Can I just ask you, you keep referring to the plus factors. In the constructive possession cases, the court usually uses that term plus factors. Do the cases here actually use that term plus factors? Is that just how you're characterizing them?
I actually borrowed it as I'm reviewing the cases, and I take a look at it and I take a look at what we have here. The evidence just isn't enough. So
no. My question was simply, do the cases say plus factors, or is that a characterization that you're giving the cases?
That's my characterization.
Okay, thank you.
and Your Honor, I don't want to, if there are no questions on this issue, I just want to quickly just say one thing about closing argument, if that's okay. I just, in preparing for oral argument, I reread closing argument, and I just wanted to alert the court to the trial transcript, page 44, and trial counsel makes the argument, there's an infinite amount of people at this point who could have taken the check, that could have signed the check and could have given it to Ms. Scordino. And so when the Commonwealth comes back and says this statement that, if the defense is attempting to make the argument that someone else gave her the check, I would argue why the check is still signed by the defendant. I think that's a clear reference to a forgery type of situation.
But the judge immediately after argument found the defendant not guilty of forgery. So the odds that it actually affected the judge seem like zero.
Actually, I'm sorry, Your Honor, the forgery count was dismissed prior to trial. The judge reiterates immediately after closing argument, I've already dismissed the forgery count, so now all we have is this, right? Well, in the larceny, which he found there was no, the Commonwealth had not proven larceny.
And you have to show substantial risk of a miscarriage of justice, right? So the odds that the judge dismissed the forgery count but somehow found forgery seem low, don't they?
I just want to alert the court to that argument made, and that the argument made by trial counsel.
I think what Attorney Yeshulis is saying is that the Commonwealth dismissed the forgery. The judge didn't make a finding on the forgery.
Oh, okay.
Correct. So if there are no other questions, I see my time is almost up. I would like to rest on my brief, if that's okay with the court.
Sure. Thank you very much.
Thank you.
Very interesting argument. And we will hear now from Attorney DeBlander.
Good morning, Your Honors, and may it please the court. Assistant District Attorney Daniel DeBlander for the Commonwealth. The Commonwealth asks this court to affirm the judgment of the Natick District Court finding the defendant guilty of uttering a false check. Turning first to the sufficiency of the evidence presented by the Commonwealth at this jury-waived trial, the Commonwealth asks that this court to affirm Judge Kunis's denial of the defendant's motion for a directed verdict on the uttering charge, and submits that the Commonwealth presented sufficient evidence as to each element of the crime, such that taken in the light most favorable to the Commonwealth, as this court must, any rational trier of fact could have found the defendant in this case guilty beyond a reasonable doubt of having uttered a check in the amount of $950.
So can I ask you the question I said I was going to ask you?
Yes,
The
Your Honor.
lawyer in Pacheco, could a jury, I know he wasn't the defendant, but now imagine he's been charged with uttering, or she, it's Maria something, the attorney.
Sure.
Is there sufficient evidence, was there sufficient evidence in that case to support a conviction of that attorney for uttering?
Your Honor, I'm a
right,
little
so
bit unsure of the facts around.
Yeah, so let me give you a factual hypothetical. A lawyer goes into a bank and deposits a check made out to him from his account into his account. And the check is made out to him, but the signature on the check is of someone he's never heard of, and it's a checking account of someone he's never heard of. He says, well, my clients frequently give me checks from people I've never heard of. They don't have any money. And so they go to their brother-in-law who has a few $100 or whatever, and they get a check because that person's willing to pay for their lawyer. And I get checks like this all day long, and I endorse them by writing my name on the back, and I deposit them. Is that person, could a jury find that person, that lawyer, guilty of uttering?
Your Honor, I do think that that does reach the baseline elements of the crime of uttering in that case. I would submit that making no effort to guarantee like how that check was received. It's a little bit a little bit uncomfortable with the hypothetical there. I think it's a little bit a field of the facts in this case.
It's not a field of these facts at all, because the only way that you would know that is if the defendant there, the lawyer, took the stand to explain themselves. But they don't have to do that, right? Whether the lawyer takes the stand to say, no, I just got this from a client, in which case, of course, he'll be, not of course, but in all likelihood, he'll be acquitted, right? or
Right.
doesn't take the stand at all and says, you're out of your mind, good luck to you. You know, I mean, that would be a tactically foolish thing to do when you have, but he has no obligation. The Commonwealth has presented exactly the same case. This lawyer walked into a bank, check is made out to him. The person who wrote the check says, I've never heard of this lawyer. He signed the check and deposited it. And my question is, I'm not saying whether maybe it was uttering, I'm saying whether that supports beyond a reasonable doubt that it was uttering.
Your Honor, I think that, it is the barest of facts, I think, that could be possible here, but I would submit that that really does meet the absolute baseline beyond a reasonable doubt. And, obviously how that would play out at trial, you would need to submit, the judge would need to credit some testimony, and the Commonwealth would have to present the sort of evidence that is present here. We've heard
Exactly
from
the same, yeah, exactly the same case. But the lawyer says, I'm a person of irrational principle. I'm not taking the stand. I spend my life defending criminals, and the Commonwealth has to meet its burden. Obviously, they haven't. How could this meet the burden? Everyone knows I get checks like this all day long. I'm not uttering.
I would submit, that there would be circumstantial evidence of that, there's no reason for that person to expect that those funds, and they're not actually owed them.
Counsel, turning to this case, and I'm glad you said that. How do we know what happened in this case of why the defendant got the check? What evidence did the government present about anything regarding that?
So I would say this is clearly a case of proof by inference and circumstantial evidence. There was no direct evidence, and we do concede that at least here. But I would say that this is substantially, and I notice I'm freezing for some reason here. This is substantially the same case as in the Pacheco case, where you have a lost check or checkbook, a signature of the victim, but testimony by, or the signature of, the victim, but a testimony that she had not signed it. And to quote at least very briefly from that case, the checkbook owner testified that she had never met nor heard of the defendant, and that the signatures of the check were not hers. And whether the defendant himself wrote or signed the check, he knowingly negotiated or attempted to use as payment checks from a stranger's checkbook.
Well, there's where I'm asking you, based on the evidence that was presented at this trial, how do we know that the signator on that was a quote unquote stranger of the defendant? You presented no evidence about that.
I would argue, Your Honor, that the Judge Kunis here was, allowed to credit the testimony of the victim here. These, we don't know exactly what happened in terms of how the check got into the hands of the defendant, but it kind of, to just go ahead and cash a check that clearly was not signed by the victim here.
But the defendant doesn't know that based on the evidence you presented. I hate using some hypotheticals, but this one seems easy to me, which is the defendant does work for person A, whatever that work may be. Person A signs the check, it's a woman, and signs Ms. Adams' name, hands the check to the defendant. The defendant goes to her bank and does entirely exculpatory evidence, gives her ID, and cashes the check. In that situation that I just gave you, what evidence is there at all from the defendant's knowledge that the person who signed that check was not Ms. Adams, and that she didn't do work to get that check properly?
I would say that here, hearing further testimony in this case, if the finder of fact would be allowed to find with evidence that the victim, never did sign that, that just the
I agree, counsel. I agree with you. I'm giving you 100% credit that the victim didn't sign the check, but that's not what the elements are. The elements are that the defendant knew that was fraudulently signed.
I believe that the circumstantial evidence presented here would allow a finder of fact to infer that knowledge. And to the extent that we're going to be discussing something that my sister refers to as like plus factor in this matter, I submit that there's at least one further factor here that Judge Kunis could have relied on. I'll cite you, and I apologize to the court. I did not cite this case in my brief, 1979 SJC case, Commonwealth v. Catania, in which
What's the site?
sorry, 377 Mass 186, and the relevant portion would be at 189. There were a number of other factors at play here. I will submit there was plenty further evidence here, but the court found no error in the denial of the defendant's motion for directed verdict and discussed at some length the number of the evidence relied upon in a finding of knowledge here. And one of those was that the defendant wanted cash for a substantial sum when attempting to make a deposit, and that was at least some evidence. In that case, it was an amount of $9,000, but I would submit that here an amount of $900 is also a substantial sum.
Well, I don't know about that. I think it depends on your socioeconomic group, where you live, culture. Some people walk around with $900 in cash and do all their business in cash, and I don't know that. I mean, 9,000 maybe. I hear you. You know, what do you need $9,000 in cash? But I mean, there are people who transact all their business in immigrant communities. I've seen this. You know, they just transact their business in cash. So you need to have. I mean, 900 might be a lot, but 400 totally wouldn't be. So I don't know.
Commonwealth, you could have sought a discovery order, right? Asking for a handwriting exemplar to see if that handwriting matched either the defendant or, again, I'll call it the co-defendant, even though technically it wasn't. But you didn't do that, correct?
That is correct, Your Honor.
So in your brief, you keep saying from a quote unquote stranger's account, cashed a check from a stranger's account. And I struggle. I'm trying to find the inference that I think you said it was Judge Kunis used to find that this was from a stranger's account, because you presented no evidence about how the defendant got this check. So how do we infer that? How do we, and I'll use your opposing counsel's language, how do we make that leap based on inference?
Sure, and I think, Your Honor, this is perhaps sort of, I've used the phrase baseline, a case of this that, we did hear testimony from the victim in this, and that the judge was entitled to credit that, based on all of the factors presented in the victim's testimony, that they did not know this person, they were not entitled to funds from her account, that any reasonable, that's sort of, and taken in the light most favorable to the Commonwealth here, that this court should affirm Judge Kunis's findings on that.
Is it your position that anyone who cashes a stolen check, that's all we know, cash a stolen check, that there's sufficient evidence to convict that person of uttering?
I would say that the current case, the Commonwealth would have to make some effort to present evidence along those lines.
Yeah, along those lines, you proved it's stolen. This person cashed it. It was made out to her or him, and he cashed it.
I would submit
stolen
that
check made out to you is sufficient to prove uttering. Is that the Commonwealth's position?
I think that this case might present a little bit more than that, but that does sound, Your Honor, and I'm sorry if I'm not fully understanding, but it does sound like that does meet the basic elements of the crime.
Anyone who cashes a stolen check can be found by jury beyond a reasonable doubt.
With appropriate evidence, and I would submit that here there's a little bit
Appropriate evidence it was stolen. Ma'am, what happened to your checks? They were stolen. Thank you for coming in.
Well, here testimonies, I don't know, right?
Right. If I see that time is getting a little bit low, would it be possible to turn to the second issue here, I would just remind the court, turning to the issue raised by the defendant concerning the propriety of the prosecutor's closing argument, that this was a jury waived trial, and that this court presumes that the judge would have apprised himself of the law in this area. To the extent there's any claim of shifting of the burden of proof, I would submit that Judge Kunis was fully aware of the burden of proof on this, especially where he had dismissed the charge of larceny.
Is it your position that no error in closing in a bench waived trial can create a substantial risk of a miscarriage of justice? Because the judge will always instruct with respect to the law, because the judge will always be presumed to have instructed himself accurately?
I would say there may be some circumstances in which that does present that a substantial risk of a miscarriage of justice, but that this is far from that circumstance, Your Honor. This is, possibly in an artful wording. I would also say that really here, though, the prosecutor was entitled to address some of the arguments presented by defense counsel as to, any number of hypotheticals about other persons here, and it was merely addressing that issue. But Judge Kunis would certainly have been aware that the arguments of counsel in closing are not direct evidence, and the prosecutor can fairly respond to those. Yes, in jury waived trials, we do make a presumption that the judge has correctly instructed themselves as to the burden of proof. If there are no further questions, the Commonwealth would rest on its brief and ask this court to affirm the judgment of the Natick District Court.
Thank you very much. I see none. You've both done an excellent job with this argument. It's a very, very interesting case. So thank you for your assistance. And it is
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Judge Rubin. I am joined by Judges Massing and D'Angelo. We are hearing argument today by teleconference, by video conference, due to some COVID illnesses, and we appreciate the assistance of counsel and of the court staff in making the transition to remote argument possible. The next case that we will hear is number 21-916, Commonwealth v. William Earl. The rules for argument are the same here as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. And we will hear first from Attorney Petito.
Good morning. May it please the court, Joanne Petito for the defendant William Earl in this case. The defendant's alleged statements to Officer Thermitis were obtained without Miranda warnings and were inadmissible because he was subjected to custodial interrogation. The defendant was chased, tackled to the ground, and handcuffed by Officer Thermitis, putting him in custody. He obviously was not free to leave, and this degree of curtailment of freedom of movement is associated with formal arrest.
Counsel, would any questions asked after the tackling and the handcuffs, in your opinion, be interrogation? Any question whatsoever?
Yes. The defendant was asked, "Why did you run?" And a question.
Well, my question isn't the questions that were asked to him. Let me change it. I'm going to assume for a second, for purposes of this question, that he's in custody. He's tackled, he's put in handcuffs, he's in custody. Under the case law, do you believe that any question whatsoever after that point is custodial interrogation?
Yes.
Like, could they have said, "What's your name"? Would that be interrogation?
Oh, you mean, no, I don't, I see what you're saying. I'm not saying that any question at all would have been interrogation.
Okay,
But
because the
he was
Commonwealth makes the perspective or points to the fact that this was what they call preliminary questions for an investigation. So I'm trying to figure out where that line is as to what turns this question of basically oh my gosh, why did you take off like that? Is that interrogation, or is that just a preliminary question of what the heck's going on here?
Well, I to that particular question, and there was another question posed after that, but that initial question, it is not, why did you run, is not the same. It's not quite the same as what's going on. I think that after an individual runs from police, has to be chased and brought to the ground, the question, why are you running away from police, is reasonably likely to elicit some incriminating response, keeping in mind that an incriminating response includes any response that the prosecution may use at trial, and it could be either inculpatory or exculpatory.
What
Okay.
about the officer's intent regarding that perspective? I know later on the intent might be different, but don't the cases talk about what's the officer's intent in asking that first question that has
Well, I
some
think
relevance?
I think the standard is how the defendant would perceive it.
Well, isn't some of the cases talk about whether the question is designed to elicit an incriminating answer? Don't the cases
Yes,
use that language?
They do, but I believe that the standard is whether the officer should have known that it was
Okay, so in this
designed. So that
in this circumstance, a guy takes off running after banging on windows. He's tackled and handcuffed. Isn't a logical question from anyone at this point, oh my gosh, what are you doing? What are you taking off for? Why are you running? They have no idea whether it's incriminating. They just want to know why did you do that?
Well, I think it needs to be viewed in the context of what is happening, that the individual did run, did have to be tackled, and is now standing handcuffed. So in that,
It can't be that, I mean, first of all, I don't believe that test applies. I mean, I haven't taught criminal procedure in a couple of years, but I thought any express questioning was forbidden without the warnings, or at least that the answers were not admissible, absent a public safety exception. But I thought that test of, and I'll ask Attorney Lynn about this, I thought that test reasonably likely to elicit an incriminating response was for statements. That's how I read Rhode Island versus Innis. But assuming that test applies to questions, I don't know why it would. Surely it can't mean reasonably likely to get a confession. It must mean, leading to some evidence, and asking someone why they ran from the police seems obviously reasonably likely to elicit an incriminating response if what the person was doing was wrong. I mean, and that presumably must be the premise of it. Oh, I thought he was a Boy Scout going to help a lady cross the street. I was shocked when he answered that he committed a crime. Just doesn't, that's just not realistic. The question is asked and it's not being asked by a nurse or somebody, which is talking, it's a police dominated atmosphere. And the reason for that, police investigate crimes. And I don't think, was there a finding that these questions were asked for safety reasons?
I don't believe there was a finding that they were asked for safety reasons. I believe there was a determination that they were preliminary questions, if my memory.
Is there some case I can look to for the preliminary question exception to Miranda? Because I'm not familiar with it.
Well, the case of Commonwealth versus Gordon, in that case, the court found that actually even preliminary questions can be interrogation. As far as a case that says that preliminary questions are permissible, I can't give you an example of that off the top of my head.
Because they're not permissible. There's no such thing.
Mm-hmm.
And this guy's second question is, why did you kill someone?
Well, that is even
preliminary is supposed to have gone on for, but it seems like it went on for about 8 seconds.
Yes. Well, the question why, after the defendant allegedly confessed to killing someone, the question why did you kill someone is clearly designed to elicit intimidating information. It's not seeking anything else. That is clearly interrogation. It's an express question.
I don't want to end your discussion of this because I'm guessing my colleagues may have further questions about this. I do want to get to the medical records before your time runs out.
I give a
Yes.
couple more on this, just a factual matter. You do agree though that when they tackled him anyway, they had no idea that there'd been a murder, right? That was they were tackled him and investigating for something completely different. Is that right?
They didn't know that there had been a murder. The officer who tackled him did say that he chased and tackled him because he didn't want him to get away. So it
Why
suggests
not?
exactly.
So
I mean,
it suggests
innocent people are allowed to walk away from the police, right?
Can I ask another question?
Yes.
Which is if suppose that the case had this had been suppressed. Judge Toshka had to suppress this. Would then the defense be that he didn't do it as opposed to he didn't have the state of mind? Or I mean, is the important thing here that he said he was running off his mouth? Is the state of mind as opposed to identity that was important here, right?
It is with respect to the second question, but the first.
But I mean, suppose he didn't say I killed somebody. Would there be any plausible defense that on this case at retrial that he didn't do it?
I mean, I wouldn't want to speculate, but there was an individual in the apartment and who found the body, who identified the defendant at the hospital. I can't speculate as to whether another defense would have been viable had that statement not been made.
So with the DNA, so you won't say that with the DNA evidence, it's and everything that you could still a reasonable defense might still be he didn't do it.
It would be a difficult defense.
Okay,
Okay.
fair enough.
So again, is there more on this? Because
I
One
did
more.
want to.
You're not making any fruit of the poisonous tree argument from this, are you? Right? It's just the statement itself. You're not saying that this statement, right?
Right. It's the statements themselves.
Thank you.
I was trying to find it in the record, but I believe the trial judge, I think it was Judge Toshka, makes one statement that the officer handcuffed him for safety purposes, for his own safety. Do you find that based on the transcript was a clearly erroneous fact that he made?
I believe the officer, and it was Judge Giles who was the trial judge.
But the motion to suppress was, anyway,
Yes,
it doesn't matter.
Yes, that was the motion judge was a different judge. I believe that, I'm sorry, can you repeat your question?
Sure. I thought that the motion judge had made a finding.
Safety.
Yes, for his own safety,
okay.
because, yes.
I believe that Officer Thermatis did testify that he handcuffed him for safety, for his safety, and I think he said something like for his safety and my safety. I did explain that would be included in the facts section in my brief. However, even if a person is handcuffed and held for safety, it doesn't mean that Miranda is not required. The stop or the seizure may be appropriate, but if freedom of movement is curtailed to a degree approximating arrest, Miranda is still required. So if there aren't any other questions on that topic, I would like to get to the medical records issue. And the first thing I'd like to say is that it was clear that these records were intended to be introduced to show that the defendant had a mental health condition and that it may have affected his mental state at the time of the stabbing. The judge understood.
To me, I looked at these cases and I find it all a little baffling. What is the difference between a diminished capacity defense, which we're told repeatedly, we don't have one, and using someone's mental illness to say, no, the Commonwealth has not as proven adequately the state of mind, which these very same cases say in the next sentence is permitted. What's the difference?
Yeah, it's a very blurry, it's kind of a mushy area as I see it. But what is clear is that evidence as to mental state can be relevant to whether the degree of culpability could be reduced, as to whether the individual was capable of forming the intent or of satisfying some other requirement, such as I believe there was.
The point is that there's no absolute defense of diminished capacity. Is that the point? Like, no, you get knocked down to voluntary manslaughter or whatever, but you're not guilty by reason of diminished capacity. Is that what they're saying?
That's the best that I can determine.
But surely there are crimes that don't have lesser included offenses, where if you negate the mental state, the person is not guilty. I mean, I obviously not murder, but.
Well, I think that the standard for criminal responsibility may be different and more a higher standard or a different standard than there is for showing whether mental state was affected. And I think that that may be the difference. And I think that that's what it was being offered for here.
Now,
Counsel, Judge Giles maybe didn't use the word relevance, but what her problem was, at least based on the transcript, seems to be is that the defendant was not connecting up the evidence of mental impairment of some type from approximately, I think it was 4 to 6 months ago, to the date of the crime in question. So can you talk to us very briefly, unfortunately, about how that connection was going to be made by the defense to show relevance?
Yes, there was going to be likely testimony from a doctor to testify that the defendant was not following his treatment plan and not taking medication. And there was an abundance of precipient witness testimony as to his state and his behavior at the time of the stabbing, incoherence, being irrational, not making any sense. Everybody who encountered him, everybody thought that there was something wrong with him. They thought he was on something. They thought that he was off. He wasn't making any sense. That can be compared
That sounds
to
a
the
lot.
context.
That sounds a lot like a diminished capacity defense, doesn't it? And your client and counsel specifically told the Commonwealth and the trial judge that you were not doing that type of defense, and yet it seems like you're trying to say kind of that it was. I guess I'm missing the point there.
Well, I think what they're trying to say is that given the health and the medical state of the defendant at the time, it may have affected whether he could form intent and malice. There was no particular assessment of mental impairment, and there wasn't anything that was going to be introduced, an assessment on that date.
So your time has expired.
Again, I'm sorry, I have a factual.
I have one too. We'll give your opposing counsel some additional time if he needs it as well. Go ahead, Judge.
I'm just want to be clear. What are you saying was excluded that you wanted in? I'm looking at the impounded appendix, and there's a report. I mean, the brief cites to IRA 24 to 28, and that report actually is one that had to do with this case. I think you're talking about the Kearney Hospital admission. Is that what?
Yes.
Okay.
Yes.
So okay. Thank you. That's what I'm.
Yes.
And
Yes.
can I ask one other question? You submitted to us a correction to the transcript.
Yes.
You run that by opposing counsel first. Is there any dispute about it? I mean, I'll ask him, of course, but
There was a stipulate. I'm sorry. Yes, I'm sorry. At that, there was a stipulation that attorney Kaylin Campbell signed. I can't recall whether I submitted that. I can submit that to the court.
As long as, I mean, I'll ask obviously opposing counsel, but I just want to make sure that we're looking at an agreed upon record and not something else. All right, your
Yes,
time
it
is
was.
expired, although if there are further questions. No? No, thank you very much. Very interesting
Okay,
argument.
thank you.
We will hear now from Attorney Lynn.
Thank you, Your Honor. May it please the court, Paul Lynn for the Commonwealth. Starting first with the Miranda issue, Judge Tochka made a very thoughtful analysis of this situation under the Gomes factors and looked and ruled that this was not custody. And I think the Vellucci case, which I cite in my brief, is directly on point. That's a case that's almost exactly the same situation. There's a car that's on the side of the road. It's obviously been badly damaged. When the officer approaches in his car, the defendant gets out of the car, starts moving toward the officer. The officer keeps saying, go back to your car, go back to your car. And finally, he handcuffs the defendant for his safety on the side of the
Counsel,
road.
Counsel, I would suggest that chasing and tackling and then handcuffing makes this case a little different.
A little,
Go ahead.
But
What I want to ask about is, do you believe sort of that the goal line has changed over the cases where it's not just finding that a person is not free to leave, but there needs to be more for there to be custodial interrogation?
Absolutely. I think that's.
Can you talk about
100%
that?
clear. The free to leave standard is the standard for being seized under the Fourth Amendment. Custody is something entirely different, and that's clear from all the roadside cases. And this, of course, even though it's not a traffic stop, is a roadside case. This isn't a police station.
Stop.
What?
Right. I mean, it's true that the courts have said that a traffic stop, because it is likely to be short, routine, and the person is not detained for any period of time. And of course, in Massachusetts, even more than that, you can't even ask if it's true road stop. There's a million things you're not even allowed to ask the driver.
Of course.
Right. So it's a different ballgame altogether. These people are on the street. He's an apparently crazy person knocking on windshields of moving cars in the rain. An officer comes up and he runs away.
Right.
Well, okay, now it's not, and he runs after him and tackles him. It's outdoors, but it's not a traffic stop.
No, it's definitely not a traffic stop, but it's still a safety stop. It's still a stop because this man is endangering himself.
Whose safety? It's for his own good that he's chased and tackled.
Correct. Because he is in the middle of the street.
It's because he appears to be insane.
Well, he appears to be a danger to himself and others. That's what he appears to be. Whether or not that's due to insanity is a totally different issue. He's engaging in erratic conduct that's a danger to himself and others. But I think the most important factor here.
Your case for police-dominated atmosphere, handcuffed, and asked a question, but you're merely being, not a traffic stop, but you're merely being detained for safety.
Correct.
And it's not Miranda. Do you have a case like that? Because I looked for one and I couldn't find one.
I think Vellucci is the case. I mean, that's
a traffic stop case.
It's not a traffic stop, Your Honor. The car is already stopped. The officer is there to investigate a situation in which people may be hurt, which is exactly the same situation you have here. The officer isn't stopping this car because it failed to use a turn signal. He is coming up to this car because it's been badly damaged. And the defendant, as in this case, is acting erratically. He's approaching the officer. He won't stop, and the officer comes out and he handcuffs him.
Let's go to the second.
The first standard. You don't have you have one officer. Two officers approach. One officer goes off to get help. The other officer is the only person there. And the most important of all the Gomes standard, the police have absolutely no evidence whatsoever at this point that any crime has been committed. The defendant is bleeding.
You think it's lawful to stand in the middle of the road and knock on windshields of passing traffic? You don't think that's a crime?
I don't think that's a crime that I can think of. I mean, it could be disorderly conduct, but that's
reckless endangerment.
Okay, but that's definitely not why the police are stopping him. That is not why the police are stopping him. They are here because they are stopping him by their own testimony, believed by the judge, for his safety. They have no interest in arresting him for wanton endangerment.
If he said nothing, you don't think they put him in the clink? What is it you were doing? You're under arrest.
No, he's not. It's not. If he did nothing, if he had said in the situation, I just got attacked, they're not going to arrest him. They're not going to arrest him for being in the middle of the street.
Let me ask
Counsel,
you.
where did Judge Tochka make a finding that they detained him or seized him for his own safety?
He believed that Judge Tochka believed the testimony of Officer Thermitis that he handcuffed the defendant for his safety.
Can you, where does he say that in his finding?
I'll double check, but that's there. I know. Hold on. Sorry about this.
That's okay. It's a long opinion, and it goes to my first question, and you can keep looking at. There seems
Yeah,
to
here it
be
is. I've got it at let's see, page 58, which is my appendix.
Your appendix, volume 1.
My addendum, excuse me. Sorry.
Okay. I'm sorry.
Yeah. Well, he credits the officer. I'm sorry. I don't think it's in his specific
Yeah.
finding. Correct.
I know he credits the officer, but I don't think there's ever a finding that and I'll use your words, seized the defendant for his own safety. I don't think there's that delineation. And that's why I asked you that first question between custody versus what custodial interrogation. I don't think we have that fine line from his decision.
I think we do, because he believes the officer, and the officer says he's you know, you go down here in his analysis. He said, you know, he definitely says it's the first thing. It's not a police-dominated atmosphere. But I think the most important thing here is the police have no idea that a murder is going on.
Who was
Counsel? Let me give you the first question, okay? That I asked counsel about. Let's assume for a half a second that very first question was preliminary and we're okay. Right. After he says, I just killed somebody, doesn't any question after that by the police become designed to elicit an incriminating response?
No, and the case that I cite for that is Bryant. In Bryant, the defendant says, I did it. And the police captain, instead of saying, you have a right to remain silent, sir, says, well, that must be good to get off your chest. Tell me more. And the court explicitly holds, the SJC explicitly holds that that's not interrogation. That doesn't make this custodial. And I think it cannot be emphasized enough that there was no crime that was being investigated here. By all indications, the defendant is a victim here. He is bleeding. According to Officer Tranfaglia, he said he was shot. So they're trying to say, again, as in Vellucci, what's going on here? What happened? And why did you run? And he's fully expecting the defendant to say, because I was attacked, because I was in a terrible accident. And instead he says,
expecting people, the question isn't, I mean, no one really expects people to confess right away. They expect them to lie, but the questions are still designed.
No, but it's the situation, it's the underlying situation that determines whether or not this is custodial, not just whether it was interrogation, but whether it was custodial. So here you have.
Can I ask you about interrogation though, one other thing?
Certainly.
Do you believe that Rhode Island v. Innis, which says all express questioning is interrogation if the person's in custody, do you believe that's no longer good law?
No, of course it's good law. The standard is whether it is reasonably likely or could be reasonably expected to elicit an incriminating response.
No,
that's Rhode Island versus Innis. Wouldn't it be?
Rhode Island v. Innis says express questioning or statements reasonably designed to elicit an incriminating response. It seems to say that all express questioning, regardless of how it's designed, is interrogation.
Well, that's definitely been changed because both Vellucci and Bryant and all the cases say that there are questions that you can ask that are not designed to elicit incriminating information.
Do you think that untreated psychosis might make it impossible for someone to form the intent necessary for their killing someone to be murder.
Yes,
So why can't these records come in? They describe untreated psychosis.
because they don't make that connection. You could connect that, you could have some evidence connecting.
You mean it just wasn't argued?
It wasn't argued and it wasn't supported.
Well, I don't
First of all,
know.
as I say, despite what my sister says, defense counsel explicitly says when asked, I am not offering this evidence to show his state of mind at the time of the crime. And that's the only thing. The difference between diminished capacity, as I understand it, I've never practiced in a jurisdiction that had it, but as I understand it, is that somehow even if your mental health problem doesn't amount to a lack of criminal responsibility, that you still can have diminished responsibility based on your mental illness. So you're not quite insane, to use your word, Justice Rubin, but you still have some problems. We don't recognize that. In Massachusetts, the only relevance besides criminal responsibility that mental health evidence has is whether it affected the defendant's ability to form the state of mind necessary for the crime. So in other words, it actually is an all or nothing, usually, unless it's in homicide, there is a degree of mental state that's required. If the defendant, because of his mental health, lacks the ability to form the required intent or the required knowledge, which are the two state of mind elements of what we used to call malice, then yes, that's a defense. That's an absolute defense to murder. It may be an absolute defense to any homicide crime, depending on the degree. But here you don't have any connection. You have all of this psychiatric language that my sister says, oh, well, tangential. That means exactly what he said. A lay juror is not likely to know that. And it's even worse, a lay juror is likely to have stereotypes about mental illness that will not be helpful. And yet what the defendant wanted to do here was throw these records at the jury at the last minute. He's been investigating the defendant's mental health for 3 years. And
am I right that they said they would bring in a doctor as well?
They would bring in his physician, who was going to say he wasn't filling his prescription. That was good. He was not going to say this set of psychiatric problems could lead someone to lack the intent and knowledge necessary for homicide.
Why can't the jury make a connection to say he has these mental health issues 6 months prior, and he's not taking his medication, which helped these mental health problems. So on the date in question, we can infer these mental health issues were back and somehow affected his intent to form the requisite state of mind. Why can't the jury make that inference?
It's the somehow problem. I mean, I think in her reply brief, my sister cites Fairweather, where you had evidence that much closer to the time of the crime, the witness, the putative victim, said, I hear the voice of my boyfriend telling me to do things. And the court said, that's the kind of thing that you can say. And of course, that's offered for the reliability of a witness who's on the stand, not on the elements of the crime. That's the sort of thing a jury can say, that might affect someone's mind. But here you've got a psychiatric diagnosis from 5 months earlier, no evidence of whether it's continued, whether it's continual, whether it would be something that will affect his knowledge and intent. Really, you need one more brick. You know, as the standard rule of relevance is, you just need a brick, you don't need a wall. But here you need at least one other brick to connect it to everything else. I do want to go back very briefly.
Why isn't his behavior and the fact that everyone thinks there's something wrong with him? They think he's on meth, but of course he tests negative for amphetamines. Yeah. All he tests positive for is cannabis. And I don't purport to know exactly how cannabis might affect every person or whatever. But there's something wrong with him, everyone says. And then it's like, well, 5 months ago, he was diagnosed psychotic, and he didn't ever fill his prescription for medication.
See, that's the problem.
Why isn't that a brick?
Because, again, it doesn't go to whether this would affect his intent, undermine his intent and knowledge.
Can I ask
You need some explanation of how that would happen in order for it to be relevant to the jury.
the submitted correction to the transcript has counsel for the defense saying, so it may go to the extreme atrocity issues and the premeditation issues, not in terms of whether or not he was criminally responsible.
Mhm.
And I understand that when you read the whole transcript of what he's saying, it's all, I mean, everyone seems to mix up this criminal response, generally, this criminal responsibility question with the state of mind question. But that sentence at least seems, well, does it seem to you like that sentence at least suggests I'm talking about state of mind, not about diminished capacity?
I think I don't think it does where he is explicitly denied that. I think really he's still not explaining how it does it. And I think that's the important thing. It's not whether it does, although he denies that it does, but it's how it does it, which is missing here. And otherwise,
Can I just this? I'm looking at the stipulation. This was a first-degree murder case, right?
correct, yes.
Okay, so I mean, so at the so arguments that it's relevant to extreme atrocity or premeditation, form of state of mind, form premeditation. That would have been that that's what we were talking about at the time of trial.
Right, that would be harmless at this point because the jury rejected it regardless. I also just
I've got just a quick question, two quick questions. The on this, the issue is relevance on the psychiatric records. It's not a question of there's no hearsay problem with the record coming in, right?
I don't think it's so much a hearsay question as it is a competence question. I mean, it's not inadmissible because it's hearsay, because it's a medical record. It comes into the exception. Okay. But the problem with that hearsay aspect of it is that you don't have anyone to explain it to the jury. They just have this blank, document that says these things like tangential and font flow, and they don't have anything
to get you back to what I might get you back where you wanted to be was on the custody, the Miranda issue. Do you have a harmless beyond a reasonable doubt argument or no?
No, I think the statement that he was running his mouth off is too important to be harmless beyond a reasonable doubt.
Okay, we have given your opposing counsel a little extra time, so if there are any more questions, no. Can I actually ask one housekeeping question? I gather no one submitted the video of the custodial interrogation, later in the day, the recorded interview. Has our clerk's office reached out to either of you to get a copy of that?
They have
not that I recall.
Okay, because but you didn't submit it in the appendix, Attorney Petito, is that right?
I did not. It is in the, obviously it's in the clerk's office, and okay. I can try to,
I mean, our clerk's office may have reached out to the clerk's office to get it. We, Attorney Lynn has cited helpfully to us timestamps, so it would be helpful to us to be able to look at it with reference to those. But I think I think our clerk's office is taking care of it. I just wanted to make sure we hadn't missed something one of you already submitted, and we're just, reinventing the wheel. So that's fine. Both of your arguments were excellent, very, very helpful to us.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Judge Rubin. I'm joined by Justices Massing and D'Angelo. The next case we will hear this one. Oh, I should say we are, due to some illnesses with COVID, we are hearing this argument by video conference rather than in person. We appreciate the assistance we've been given by counsel and by the staff at the court in making that possible. The next case we hear will be number 22-111, Commonwealth versus UMANA. Our rules by video conference are the same as those that we have in the courtroom when we are live, which is to say it's 15 minutes per side and no rebuttal. And with that, we will hear first from Attorney Nyman.
Great, thank you, Justice Rubin. May it please the court. My name is Steve Nyman. I represent the defendant. I did not represent him at trial. There's a few issues before the court, but given the time limitations, I just ask that we focus on the first issue. It's my opinion that it's the strongest issue that the defendant has, and it's probably the one that would take the longest to address anyway. I don't think there's any dispute that that the rape shield statute was not really in question here. I know that the trial attorney for the Commonwealth made an issue out of that. I think that the trial judge was pretty clear that and understanding that this wasn't about the victim's sexuality. It wasn't about promiscuity. It's our position, though, however, that by not permitting the defendant to get into this information, he wasn't given a fair trial.
Counsel, let me ask you right there. And I know you are also a trial lawyer, so I'm going to ask you to, I guess, put your trial lawyer hat on for a second. Let's assume the evidence regarding the allegations against GAR were admitted. In other words, counsel was allowed to cross-examine the victim or produce any other evidence regarding GAR. What would the argument then have been to the jury as to why that evidence is relevant to this case?
Well, because that was, if she was in fact abused at all, number one, that was the person who did it. But they had this family dynamic going on where she knew that no one was going to listen to her or believe her if she had made a reference to GAR. He was in good standing with the family. He was still living with the grandmother. He still had a relationship with the aunt. But rather, UMANA was removed by about 7 years from the family, or at least 5 years, depending on which version of the facts you want to look at. And it was sort of an easy target for her. The argument to the jury is, look, she made this up regardless. And she blames two people. Number one, she gets caught on her cell phone by her mother in what appears to be having some sort of a relationship with a man who's 10 or 12 years older than her. She's 13 at the time. This man that she's either having a relationship or sort of trying to have a relationship is 23 to 25 years old at the time. She immediately deflects and says, no, that's nothing. And by the way, your ex-husband had abused me a while back. I mean, just think about the timing of everything. So they right from that disclosure, they shortly thereafter go over to the doctor's office. There's no doctor to meet with them. So
hold on. I'm going to back you up just a second. So within that span of approximately 10 seconds where mom wants the phone, she says, no, I'm not giving you the phone. And by the way, I was sexually abused. In that 10-second period, her state of mind is, I'm not going to blame my uncle who's doing it to me now. Instead, I'm going to blame my stepfather from 7 years ago. That's what you would have asked the jury to believe.
Well, I certainly would have asked the jury to believe that, but I would have also developed it a little bit more than that. And so, I mean, that was a quick answer based on, your question, Justice D'Angelo, but it would have been developed more than that. And it would have been good. And it would have been very good.
How? I'm wanting that follow-up. How would it have been developed? What other evidence was there that could have been developed that was excluded?
She makes this up. She makes this up about two different people. As a matter of fact, there's so many similarities between it. It happens at a relative's house.
Wait, I'm sorry. So is she made it up about two people, or actually one really did it and she made it about the other person? Like you switched on that.
In either or, to be quite honest with you, I mean, but our argument would have been certainly at where I try in the case that UMANA did not do this. That's the first thing. The second thing, if anyone had anything to do with this, if she was in fact abused, and we're not saying that she was, it would have been by GAR. However, this is who this girl is. She makes things up. She got caught by her mother in an uncomfortable situation, and the first thing she was going to do was take the attention away from what she knew she wasn't supposed to do and get some sympathy for herself.
Well, hold on, counsel. That was not raised with the trial judge, was it? It wasn't that the allegations with GAR are false, and therefore this goes to her credibility, and she's making everything up. It was what I think you alluded to first, which was she's making it up against defendant because she's protecting uncle. So how do you leap to that other one? And wasn't that waived at the trial court because your trial counsel didn't raise that as prior false allegations?
Well, that's a different question. I was responding, Justice D'Angelo, to your first question about what would you do wearing my trial attorney's hat, and then Justice Massing was saying, so your theory would have been so, and I said no, that my theory would have been different. If we're going back to what the trial attorney did, look, what he would have done and what he tried to do are probably two different things. He made a good effort to try to get this information in. He did a good memo, and he made a good, compelling argument.
So does this mean that you are no longer arguing that sexual knowledge came from GAR?
Oh no! I'm still arguing that, and we can get to that. And that was another thing that my belief is that the trial judge made a mistake on. She was focusing on the GR thing happening after, but that's not the context of the disclosure here. So usually,
I'm sorry, just really quick, to the disclosure itself. I've got the offer of proof here. It's at Record Appendix 28, and it's just, and it has a footnote. So this is based on medical records, DCF, grand jury. Am I correct? We don't have before us the medical records, the DCF report, or the grand jury. All we have is the offer of proof.
Right, they weren't part of the trial record, but all that information. I mean, if you're asking me, all that information is in there. It was in the DCF report. Had both the defendant and the uncle referenced in it, and that was also from the medical provider who contacted DCF. I think it was the.
But I mean, so for us, what we're evaluating, all we have in front of us is this. And the detail of it is that GAR would touch her under her clothes with his hand in the bottom and front and back. That's all. That's the only detail we have of the allegations against GAR.
Right, and you're not going to get. You wouldn't have got much more detail if that's what you're asking, or any more detail from those documents. So,
okay,
I think the record satisfies what the defense counsel was, the information that they had, and getting it to the court. So I kind of forget where I was, but I think it had to do with
was it the sexual knowledge coming from GAR?
Yes. So the trial judge was focused on this information, or that act being subsequent to, or the defendant's act being. That's not the standard. So usually when this comes up in a trial context, for instance, you have somebody who was allegedly violated, and then you want to get into a subsequent act. But then the rationale then for excluding that is you're saying, no, that happened later. So you're attributing the sexualized knowledge to something that was after the fact. Well,
counsel, I agree. It makes no difference whether it's prior or subsequent. But based on what Judge Massing just talked about regarding what's in the record appendix, which is frankly really the only thing we can use is that offer of proof. What was in there regarding sexual knowledge? It was a very brief statement about she was touched under her clothes. Where are you getting that had anything to do with her sexual knowledge?
Well, I mean, that was it. I mean, that was what the reference to the sexual knowledge was. I mean, it was different, obviously.
Well, don't the cases when they talk about sexual knowledge talk about how would someone of such a young age know about ejaculation? How would they know about, I hate to get descriptive, but penises? How would they get to know about other things? That's what is used by sexual knowledge in those cases. In this offer of proof, there's nothing about that.
Right, and I think that one of the problems was the trial judge was then getting confused and started to say things like, well, in this day and age doesn't matter because you're going to get all that information on the internet anyway. So I really think what was happening was she was confusing what the defense was trying to do with two things that she had in mind. Number one, that the GAR Act was prior, which doesn't matter given the time of this disclosure. And the second thing is this sexualized information wouldn't make a difference because she could have got it from the internet. That's not really the basis. You know, these guys, the defense attorneys, did a really, really good job laying the foundation for this is a credibility issue. This is a motive issue. This is a bias issue. And we
Did
really—
defense counsel ever ask the trial judge for a voir dire of the victim to talk about what she would disclose about GAR? Because a lot of this seems to maybe could have been flushed out on a voir dire. Was that ever requested and denied by the trial judge?
I don't, to my recollection, no, I don't really believe so. And I did see somewhere that the issue of voir dire came. I think it came up in one of the cases that I cited.
Well, when you're talking about rape shield, which I know, and I'm going to talk to the Commonwealth about that, and I know you both have agreed it's not rape shield, but in the context of rape shield, there's usually a voir dire of the victim, and I believe that's where it was talked about in the cases. But again, counsel, we're limited to that very brief offer of proof, and I am having issues with. You seem to be trying to go beyond that as to what the defendant would have shown to the jury beyond that. And I just am trying to struggle how we can either infer that or do that from this record.
Well, you can certainly infer it from what the information the doctor provided, that when the GAR stuff came up, she started shaking and broke down. Not when the stuff relative to Louis UMANA came up, but when the GAR stuff, that's when she had her meltdown. That seems to be the one that has impacted her more. And it was certainly something that the defense wanted to get out. I'm confident would have made a difference. And I'm not even sure in retrospect that Judge Roach was as confident in the facts as the jury was, because look at the sentence. She gave a 10 to 10 in a day, you know, and I know that's a huge sentence to begin with, but that's the minimum, and she gave the minimum. So, and that's not so common as a result for sentencing on most of these cases. So it says something in and of itself right there, Justice D'Angelo, and it's troubling. It really is troubling, because I really do believe that had this information come in, you're going to get a totally different result here. You're going to get an acquittal.
I guess I'm going to give the Commonwealth a preview of something I'm going to ask him, but I'll do it anyway. The judge, when dealing with letting in the evidence, it seems to me used the wrong standard. She specifically said that the evidence was going to be excluded because the proffered evidence is insufficient to outweigh the prejudicial effect to the complaining witness. That's the rape shield standard, correct?
Correct.
So the proper standard should have been a straight 403 standard, which is, was the evidence substantially outweighed by prejudice? So since it seems to me that the standard was not, maybe she just phrased it inappropriately, I'll leave it at that. What do we do with that? Or what can we do with that?
Well, I mean, you can reverse the
well,
that's the first thing you can do.
Well, okay.
I mean,
That was a bad question. What I meant by that is, do we just say the judge followed the wrong standard and therefore that's it? Or do we look at it and say, even if we apply the correct standard, which I think is what the Commonwealth is going to want to argue, the evidence still should have been excluded? Which do we use, the improper standard or the proper standard, I guess?
Well, I guess you could use both, to be quite honest with you, but the proper standard was one that was certainly advocated by the defense. That was referenced in their motion. It should be.
But we have to find it otherwise admissible before we even get to weighing the prejudice and the probative value, right?
Right, but I'm assuming, well, I shouldn't make any assumptions, but I'm hoping you're going to get there. I think admissibility really isn't an issue. I mean, it's clear that this should have been, well, I guess it is an issue, otherwise I wouldn't be here right now, but.
Well, your opposing counsel says quite freely, it's not relevant, period. It had nothing to do with anything. So he's arguing it's not relevant at all.
It had everything to do with motive, everything to do with bias, and everything with giving the defendant his right to a fair trial. And I just want to point out a typo real quickly. I meant to do this at the outset. On page 38, and it's also in the table of contents, I cite Commonwealth versus Owen. I have it at 7 Mass Appeals Court. It's actually 57. You guys probably already picked up on that. I apologize, and I kept that number wrong in the table of contents, or the table of authorities too, which would be on page 5. So it should be 57, not.
Thank you very much. All right, your time has expired unless there are further questions from the panel, and I do not see any. Thank you very much. Very good argument. We will hear now from Attorney Lynn.
Good morning, Your Honors. May it please the court. Paul Lynn for the Commonwealth. Yeah, but regardless of the standard, and I think there is a problem with the standard the judge used, because I agree 100% that whether it's prior or subsequent isn't the issue. The issue is it relevant? And whether we look at that through the lens of the judge's discretion or this court's independent review, it's not. There is no rational tendency for this evidence regarding GAR to have any tendency to show that the accusation against GAR is false, and therefore she makes false accusations under Bohannon, or that GAR was the only true abuser.
Attorney Lynn, what about I'm troubled by the closing argument of the prosecutor when she knows this at least vague allegation about GAR is out there, and she repeatedly says she has no reason to make any of this stuff up. There's no way she would have just come in and made this up. Well, the defense proffers that this is why she made it up, because of GAR. Is it proper? My question is it proper when a prosecutor knows that there's evidence that has been excluded to make that type of argument?
If there's relevant evidence that has been excluded for some other reason, say it's been suppressed or something like that, yes. But here, the defendant has made a completely bogus proffer of evidence that is completely irrelevant under a theory that has no rational tendency to prove anything. The prosecutor is free to say there's no evidence, because there is no evidence. There's no competent evidence. There's no relevant evidence. This is an entirely proper argument. I can take other questions, but otherwise the Commonwealth is content to rest on its brief.
Well, I guess I'll jump in then. How was the uncharged masturbation episode? What was that actually relevant for? Because I hear this, and I'm going to put it in quotation fingers, nature of their relationship. Can you explain to me what the heck that means?
It's the language comes from a long line of case law regarding abuse of children, regarding domestic violence. I shouldn't abbreviate it. Court domestic violence cases, just to show the entire relationship between the victim and the defendant. So based on which the fact finder has a better sense of putting all these, of the context in which all these events occurred. That's the rationale. That's what all the case law says. It's certainly would have been within the judge's discretion to say no evidence whatsoever. There's enough, no superfluous evidence whatsoever. There's enough evidence here of the charged acts that you don't need to get into anything else. But here you have a single incident. The judge looks at all these incidents, the charges against the other woman, the anal rape, and says, no, that's out. But this one incident, I want to give the victim some freedom to testify of what she actually remembers, even if this single incident wasn't actually charged. And the defendant can cross-examine. And then the judge explicitly instructs the jury, you cannot consider any uncharged evidence as evidence of the defendant's guilt or of bad character. So under those
But
circumstances, this
In
is,
the absence of a due process problem, there's longstanding case law about this here. I mean, obviously there's some question, maybe for all of us, about what exactly this is showing that isn't just uncharged conduct or propensity evidence or whatever. But in the absence of a due process objection, this seems, I mean, I've seen dozens of cases with this kind of thing in it.
yeah, it would certainly be within this court's discretion or the Supreme Judicial Court's discretion to limit this further. But in this case, clearly, you have several charged incidents and then a single incident that's no worse, and in fact, not nearly as bad as the rape, as the vaginal rape allegations. Certainly, no risk of prejudice whatsoever.
I promise to my colleagues this will be my last question, but
You're
since
entitled
the
to as many questions as you like.
I'll take
since the advent of the internet, which has been raised a few times in our case law, what are we supposed to do nowadays with sexual knowledge? Because the cases seem to say now that the internet, who knows what kids know and who knows what age, but that was a basis by which the judge talked about excluding or said it wasn't relevant. So what do you think we should do about that for future cases? Because it is relevant in this case slightly.
Well, I mean, certainly it's one factor. Certainly the internet has completely changed access to pornography. It's out there. You know, I don't want to get off the record, but you know, I know children who have, you know, who've talked about it and said they can get access to it. So I think it's certainly that sense that you might be able to bring in another act to show knowledge is getting weaker and weaker by the day. Whether it's completely irrelevant, that's a good question, but it's not really one that's presented by this case.
How
We
old
have
is,
no, I'm sorry, go ahead, Judge.
how old is the victim when she's testifying at trial?
She's a late teenager. She's 13 when it, or no, she's younger. She's 13 when she's testifying, and she was 7 or so when it was
Okay.
happening.
I mean, so
I mean, you'd have to have a fact finding, wouldn't you? I mean, I have no idea at what age, 9, 13, 15, 14 children, by and large, are exposed to this kind of stuff.
No, I don't either, but it's, they do seem to be able to get their hands on it.
Can I ask you to go back to the GAR evidence? I mean, wouldn't it be relevant that to the defense that the victim is being abused by 2 different abusers? So she might actually be confused as to who did what and when, and they're both these sort of, you know, father figures.
Yes, I addressed that in my brief. I think if there had been any substantial similarities between the abuse, that would be a fair argument, but there aren't. As this court has noted several times, the only evidence of what GAR did is that he put his hands down her clothes. There's nothing like trying to rape her, sticking his, I don't want to get too graphic, but you know the evidence in the case. There's no evidence of this much more penetrative and explicit kind of abuse. There's just this.
But shouldn't counsel have been able to probe that in cross-examination? Because the reason why there might not be more evidence of what occurred is during the DCF interview, she broke down and started crying and stopped. So there might be more information. It could have come out during cross-examination or voir dire.
Yeah, he could have requested a voir dire, but he didn't. You know, if there's no evidence on the record right now that there's anything out there but the fact that he put his hands down. And of course, as my brother points out, this is a close relative. Obviously, she'd be upset that this close relative is reaching into her pants. If there are no further questions, the Commonwealth will otherwise rest on its brief.
Okay, thank you very much. Very good arguments on both sides.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justices Massing and D'Angelo. Due to some COVID illnesses, we are hearing the case by video conference, and we appreciate counsel's flexibility and the work of court staff in assisting us to organize this. The next case we hear will be number 22-102. That is Cormier versus Murray. The rules here are as they are when we hear oral argument in person, 15 minutes per side with no rebuttal. The square on your Zoom screen in which the court seal currently appears will be replaced by a clock when argument begins, which counts down from 15 minutes. Unlike oral argument in the court, there's no change of color near the end, but it will be right, the clock is right on your screen and will be obvious to you. So with that, we will hear first from Attorney Lane.
Thank you, Your Honors. My name is Henry Lane, and I'm representing the Cormiers in this case. As I suspect the court is familiar with the documents, so I'll just very briefly discuss the facts.
Actually, I'm a little confused by the documents, and maybe you could help me with that. The certificate of title that we're talking about is RA4vc with, and is that right? Record Appendix 358, and it's got this handwritten thing on the bottom right. Or is there a different certificate of title?
That's correct, Your Honor.
So that's it. And then is there any dispute that what is attached to that is 2 pages before 356, the Office of Collector of Taxes Municipal Lien Certificate? That's supposedly attached to the certificate, or that is attached to the certificate title. Is there any dispute about that?
Yes, yeah. The certificate of municipal liens is attached.
Okay, so your clients receive the certificate of title and that has some scribbles about betterments, and then they get this assessment that mentions an uncommitted betterment of $23,000 some dollars.
Right.
Okay. So I mean, I guess it leads to the question, like, regardless of whether Attorney Murray had a responsibility to put that information in specifically in the title, aren't your clients pretty much on notice of it?
Well, their arguments, their affidavit suggests they were totally unaware of it until several years after the closing, when the bank advised them that their tax escrow was insufficient because they had not accounted for the betterment assessment payments that were due. And I guess there's conflicting evidence as to whether they actually received the certificate of title or didn't, but in any event, they don't recall it. But as I'm sure Your Honor is familiar, if you've ever had the occasion to sign a mortgage, that you were basically with dozens, if not hundreds of documentation, which in real life, nobody can actually read at a closing, and you sign a lot of things without understanding what they are.
So what should have Attorney Murray have done, a lawyer with his practice, a reasonable lawyer in his practice? What should he have done to flag this issue, other than putting it in the documents in writing, which your clients, frankly, said they weren't going to read? They didn't read.
Well, if you look at the certificate title, where it lists the encumbrances, it says none. And clearly what the statute requires is that instead of none, it should have said there's a betterment lien for $23,000 recorded in book X, page X. That's what he should have done. That's what the statute requires. There was a recorded lien, was properly indexed, and it should have been on the certificate of title. I would have put the Cormiers on notice that there was a $23,000 lien on the property that they were going to be required to satisfy. But this is much like, to use the Sherlock Holmes analogy. This is the dog that didn't bark. Since there wasn't an indication that there was a lien, nobody took notice. Had it said in standard print by the way, there's a $23,000 lien on the property, Cormiers would have picked up on that clearly, because that would have been brought to their attention and would have said, hey, we didn't agree to pay a $23,000 lien. That wasn't part of the deal, but it's not there. So it's, in our view, it's a very straightforward case. The statute says, and again, the statute's there for the benefit of the homeowner. I mean, the statute is remedial in nature. It was designed so that innocent purchasers of residential would know if there was encumbrance. So the statute clearly would have required Mr. Murray, Attorney Murray, to put the lien on the certificate. He didn't do it. And we're mystified by the judge's decision that the lien wasn't recorded or indexed. Clearly it was. In the record, we have a copy of the index showing the lien. We have a copy of the lien showing there's a, I think, $23,600 lien attached to the property at that address. It's just mystifying when the judge conclusion that it wasn't there. And in fact, at best, Mr. Cormier indicates that it's lien, at least a dispute.
Whoops. Attorney Lane.
Or wasn't indexed.
Attorney Lane, we are having trouble hearing your audio in the last couple of sentences in particular. And I'm not sure what to do about that, but we'll give you a little extra time at the end if you need it. But if you could repeat what you just said, I don't know if it's a bandwidth problem or if we're going to have to reconnect. But if you can go ahead with your argument, but the last 2 or 3 sentences were garbled. And I apologize.
I'm sorry. I don't know if that's at your end or our end, but up to now we've had pretty good pretty good audio. But anyway, what I was saying is that the certificate of title indicates that there are no encumbrances on the property. Clearly erroneous. And the statute requires that the certificate of title specifically enumerate encumbrances. Here the word certificate is none, that there are no encumbrances when in fact there clearly was an encumbrance. So the statute clearly required Mr. Attorney Murray to specify on the certificate of title that there was a betterment lien in the book and title in book and page in the amount of $23,000. He didn't do it. Had he done it, I suspect that the dog would have been barking and the Cormiers would have realized, look, you know, there's more to this than we agreed to.
Can I ask a question?
Yes.
So it is obvious from the title search that there's a lien, and it's that page 356, right?
356 is the page. Yes.
That is, you know, it's got a little stamp on it. It's actually in the registry of deeds. And so what you're saying is, go ahead.
The certificate of municipal liens was recorded after wasn't on record prior to the closing.
Please, you broke up again. So repeat that, please.
The certificate of municipal liens was not recorded.
So what was recorded? What was recorded that Attorney Murray should have found that you say he didn't?
The betterment assessment.
And what page of the record?
Do we have a copy of that?
We do. It's a page. It looks like it's unfortunately my copy is very small. It's page 391.
Can I ask you this? And I'll ask opposing counsel this question as well. Let's see. As per attached schedule. And this schedule goes on for many pages. Your opposing counsel argues that doing a search only of those records indexed by property address is adequate. I take her to be arguing essentially, although I will ask her, that as a matter of law, if an attorney undertakes such a search without searching the name of the property owner, only, that is, things indexed, and I don't know who prepares this index, but a title search for record title is, as a matter of law, non-negligent if it includes a title search by property address. not including a search of the names of the various owners during that 50-year or more period to see if there's anything else on record with respect to the property. Do you disagree with that?
I'm sorry, the question broke up a little bit. I think I can answer it. That is that you don't do searches by property, you do it by owner. And in this case, it's very clear. The index is on page 399. It's shows Mr. Borchi as the person assessed, refers to the document on page 391. On page 391, if you look at the document, Mr. Borchi at 29 Fairview Drive is listed as having.
No, I understand that, and I don't understand how things get indexed. Who decides whether to index it by name, property address, both? I assume that's something at the registry, but I know nothing about that. It's all electronic now. I don't know how it used to be, but I just want to make sure that I understand your position. Your position is a lawyer is not protected from a negligence claim by doing a thorough search of the property address. That is not a safe harbor for a lawyer who is supposed to be figuring out whether there's an encumbrance on the record title.
Absolutely not. Property is not indexed by location, it's indexed by owner. The index runs by owner. Now, as a courtesy, the registry also includes addresses, but the address on an instrument is only there for the benefit of a local assessor, so they know what property is taxed. It has no effect on the indexing. The indexing is solely under the owner. And in this case,
you say that, you mean as a matter of law, as a matter of regulation, as a matter of custom and practice?
My understanding is that's the registry regulation. That property, again, I'm assuming a lot of things because I've been in real estate law for a long time, but indexing never occurred. It's never been indexed by, there's no way to index property other than a computer search randomly. Indexing is always by name. And as you'll see, you'll see the index. The index is there at page 399. It's indexed by name. That's how it's indexed. And there's no other way to really do it because instruments aren't required to have addresses in every case. Sometimes they do, sometimes they don't. It's the name that's the critical issue. And in this case, it's very clear. We have the index is there. We have the actual instrument. It shows a lien of $26,000, shows the address, right in the document. It shows Borchi's address is 29 Fair Drive. It's to me that the judge could find that it wasn't, as I indicated, the affidavit says it's on record. The record is there. That's in our view the fundamental flaw. The judge misunderstood the facts.
And can I ask? Okay, and can I ask a further question? It appears to me that a jury could find, I don't know this as a matter of fact, that Attorney Murray did not understand this little notation at the bottom of the lien certificate to mean that there was an already outstanding balance due of $23,931.42 as a result of this betterment. And the reason I say that is when you look at his certificate of title, number 3 is such taxes assessment. So this doesn't include such taxes, assessments, or municipal charges that may be due and payable and not shown on the attached copy of the certificate of lien, suggests that he says there's no encumbrances, but there might be something that's not shown on the certificate of lien. Whereas, of course, this is, although I find it confusing, shown on the certificate of lien. He then goes on to say, and one, it seems to me, might read this as saying there's nothing on the lien. The next sentence on the certificate of lien, the next sentence reads, the certificate of municipal liens indicates that real estate taxes on the property have been paid through 9/30/2017. It would be very odd if he, if he understood what it said in the certificate of lien, it might have also read, comma, however, there is an assessment due of $23,000. So I want to ask you this phrase, please call the assessor for final betterment payoff. uncommitted betterment balance is 23,931.42. Do you think that's readily understood to mean you owe right now $23,000? I mean, I've never heard of an uncommitted betterment. I don't know what that is even. But that doesn't mean, I mean, we don't get a lot of betterment cases, so that may be just me.
Yeah, well, the handwritten note, we don't even know when that was put on or who put it on. But I think if you,
Not the
I think,
handwritten, the typed, I'm talking about the typed language at the bottom of the certificate of lien, uncommitted betterment balances. I'm sorry, we didn't hear any response. Do you understand that? Does that clearly mean that there is a balance currently due and payable of $23,000 uncommitted betterment balance?
the uncommitted betterment balance means that somebody agreed to pay it in installments, and that there are outstanding installments that have not been added to the tax bill. That
And
will be in the future.
what does uncommitted mean?
That the way it works, when a betterment assessment is made, like in this case, you have a choice. You can either pay it immediately or you can pay it over a period of time, 10 or 20 years. The portion that you defer to future years is considered uncommitted because it hasn't been put on a current bill. It will put those future years.
I'm sorry, Attorney Lynn, after it hasn't been put on a bill, you're just breaking up, and I think it's an important answer. So if you could try again, I'm sorry about this.
Okay. When a betterment assessment is made, the owner has the option to pay it immediately or to pay it over a number of years, like a mortgage. If you decide to pay it over a period of time, a portion of that assessment is added to the bill every year for 10 years or 20 years or whatever the period is. The portion that is due but has not been put on an annual bill is considered uncommitted because it will be committed in installments in future years. So that's what uncommitted means, that it's due in full, but it's going to be paid in installments, just like mortgage. When you take out a mortgage, you owe the whole amount, but you don't get billed for it over 20 years.
Okay.
But I mean, the argument is when you look at that sentence 3 on there, it says it's an exception. It doesn't say that the taxes shown on the certificate are an encumbrance. It says we're taking the exceptions for anything that's not on there. So it doesn't say the taxes shown on the certificate are due. So it doesn't list it as an encumbrance. It lists as an encumbrance and exceptions only taxes that are not shown on that certificate. So, but in this case, as I say, we never get to that point because Attorney Murray just never put on the certificate of title that there was a recorded and indexed betterment assessment.
Okay, your time has expired unless there are other questions from the other panelists. We will hear now from Attorney Sheehan.
Thank you, Your Honor. May it please the court. I'm Jennifer Sheehan, and I'm here for appellee Daniel Murray. I'd like to touch on a couple of things. First of all, the discussion about whether the betterment lien was, and I'm using quotes here, properly indexed. There's really nothing in the record that would create a foundation for saying that it was properly indexed or, to the other side, improperly indexed. What we do know is that it was indexed first under the Cedar Meadow Lake Watershed District, and then by attachment of a schedule, which was listed according to property owner and not address. So,
okay, why haven't you just said there's a genuine issue of fact about whether this was indexed in a way that it should have been found?
Because let me get to the second part of that is that goes beyond what he's required to do on the statute. The statute, first of all, and I will say it, there's not a lot of case law on this statute, but the case law that there is indicates that the attorney's obligations under this statute are very narrow. And so there's a couple of requirements. It has to include a title exam going back at least 50 years, which was done. It talks about, it doesn't say how that title exam is to be done, but it does say that the earliest instrument should be a deed which does not on its face suggest a defect. And I think the reference to the deed is important because the deed goes with the property. And so there's really no premise for my brother's argument that there should be a search under a name.
Well, I got to tell you, this concerns me a lot. This really concerns me a lot. The lawyer's obligation, it says the certification shall include a statement that at the time of recording the said mortgage, the mortgagor holds good and sufficient record title to the mortgage premises, free from all encumbrances, and shall enumerate exceptions thereto. And I am very concerned about us articulating a rule that you can't be negligent as long as you search by property address. I mean, I don't know enough about it. Maybe that's all you have to do, but I wouldn't want to. I mean, that may again, I don't have any facts about this, but you just said there's nothing in the record about how you're supposed to do it. I would hate to say, oh, lawyers are now off the hook for anything that's recorded by a name of owner. It may be more work for them, I don't know, but it does say that they have to say record title, and it's clear this is a document that's of record. Do you see what I mean? I don't really like the idea of having to say, look, as long as you search by address, you've done your due diligence. I don't know if that's true. I mean, it might be a jury question or it might be a legal question. I don't know.
Okay, well, the other part of this, there's a couple pieces if I can answer your question in that way. There were 3 exceptions, or there were numerous exceptions listed on the certificate of title to the good and clear record title, so that could possibly be encumbrances. And one of them we've discussed, which is the assessments that are due and not listed on the municipal lien certificate. I will address that by just saying that I don't think that gives a buyer the ability to just disregard what is listed on the municipal lien certificate. But
I'm not sure about that. So the certificate of municipal liens doesn't have to be included right in the closing, just certificate of title. Am I wrong about that?
No, but in this case, the certificate of title specifically referred to the municipal.
But it says the only exceptions, the only possible exceptions include those not listed on this. Now,
okay,
your client is the lawyer here. So a lay person looks at it, if they do. I mean, what really happens, and I guess we'll get to causation in a minute. I assume what really happens, you say in your brief that Attorney Murray takes the position, I don't know if this is in the record or you're just taking this position, that he went over the certificate of title with them. So you can imagine someone going over a certificate of title. I don't know if you've ever closed on a house, but if you have, you know there's 200 documents. And of course, the person turning the pages, who's the lawyer, says, and this is a disclosure about lead paint. It shows nothing, there isn't any. Turn the page. This is a disclosure about whatever, about your rights as a borrower. This is a disclosure about your title. It says it's clear, and turns the page. It's unsurprising that someone would say, I don't remember whether I saw it or not when it's one of those 200. But of course, if the lawyer in turning the pages says, this is your lead disclosure, this is about lender's rights, this is your certificate of title. It says that you have clear title except for the $23,000 you owe, and turns the page. I think that would grab someone's attention pretty well when it's 8% of the purchase price, right?
Sure, but
if we assume even that it was the obligation of the client to read this thing, they would have no reason to turn even to the certificate, the lien certificate. It says right on it, the only encumbrances are those not shown on the next page. Okay, great. I don't have to look at the next page. And then we could even go further and say like, well, but if you did, that next sentence, and I think this is a jury question, might be read as an indication. And I'm telling you, if you do look at the lien, you'll see your property taxes are paid. As if that's all it's about. I mean, I have to say my guess is, and I'm not a fact finder here, that Attorney Murray no more understood that little call 1-800 nonsense at the bottom of that thing as an actual statement, either didn't notice it, didn't understand it, didn't whatever. You know what I mean? That's what it looks like to me.
Sure, but I will say, but okay, I guess I would like to back up actually, because before we even get to the certificate of title, the appellants were absolutely on notice of the existence of this betterment lien. It was disclosed in the MLS listing. It was actually specifically referenced when they made an offer to purchase. The seller countered with accepting their terms and the price and everything.
Counsel, can I ask you, I was going to ask you about that, but I'm going to flip it on to Attorney Murray for a second. You would agree that if Attorney Murray had somehow learned about the lake betterment, somehow, he would have been obligated to either tell them, the appellants, or put it on a document, correct?
No, I don't think he is under the statute. I mean, I think that he.
So if he did do what the appellants would say is a proper title search, and he found out about that, you don't think he has any obligation to have put it on the closing documents?
Well, I would, okay, actually, so let me say, it was on the closing documents. I apologize. I didn't mean to say that. But what I meant to say was that there's nothing under the statute that requires him, it requires him to enumerate exceptions to the good and sufficient record title. And
do you think that it's an encumbrance on the record title?
I don't know about that. I am not sure that it is. There's a case that talks about an encumbrance is something that prohibits the owner from exercising domain over the property that he would be legally entitled to. And it's not clear that this encumbrance, clearly the property conveyed with it on it. It wasn't, it's, you know, so I think there's a question about whether it's an encumbrance.
Don't you think that Attorney Murray thought, based on the second sentence of that number 3, that if that certificate of lien had said property taxes due $1,800, that he would have put it on as an exception? Instead of saying you have no property taxes, he would have written, except you do owe property taxes of $1,800.
Sure, but I think there's a question about whether a betterment is the equivalent of a property tax. It's a little bit different. And I think that I think that also the difference in it also was that it was part of the P&S, it was part of the counteroffer.
Can you read to me the language from the P&S and the language from the MLS about the betterment? I don't have that from me. Do you have it? I don't want to waste your time looking.
Let me see if I can get it on my screen. It's on page, it's the record appendix at 51 is the MLS, and it's disclosed in there. And then the offer to purchase is 54. And I apologize, I don't know if I can.
No, that's fine. I have the whole thing in front of me, so.
So I guess this kind of avoids the question then. So I was going to ask you, so if Attorney Murray had reviewed the P&S documents and maybe the MLS, but I'll leave it at the purchase and sale, and he saw that lake betterment, you don't think he had any obligation to disclose that?
I think if he had, but I also think we have to remember that he's in this transaction as the closing attorney. So I don't think he read the MLS listing. I don't think he had any obligation to do it. I don't think he saw that. I don't know. I mean, I honestly don't know what he saw and what, but there's certainly no requirement in this statute that's the basis for this claim that would require him to go back through every document that the Cormiers had seen.
No, but he should go over everything of record.
Sure, and it's his position that he did, that he did disclose that the betterment was reflected in two key places at the closing, and that he discussed it with them. So one was on the municipal lien certificate, and I understand that there's, you know, we can disagree about how effectively that was noted there, but there was something there putting them on notice. And then there was a line in the closing documents that talked about an assessment. So, and that was paid as part of their as part of the closing.
And it showed that $23,000 is shown on the closing document?
I don't think it's the 23,000, it's a payment towards that. So but again, I think we need to really look at the issue here is that there's a statute that prescribes what the attorney's obligations are. And I think that's also important to look at the purpose of this statute, which is not necessarily to put the buyer on notice of anything that could be tied to the property, but it's to ensure that the property, that the seller holds title of the property. Originally, this statute, it has been amended, but originally it had wording that it was for the benefit of the mortgagee only. And it was narrow, and it was basically, this is for the bank to know that we can get this property if anything happens. It was later amended, and it was to the benefit, so it was added for the benefit of the mortgagee and the mortgagor. But again, it doesn't change the purpose of this statute, and that it's just to make sure that the property can be freely conveyed by the seller if he wants to. And again, this betterment was assessed what the previous owner was on it, and he conveyed it, and the fact, and he disclosed it. And I think there's some case law, and I don't have it in front of me, but I can get back to you with the sites that talk about the ability that you can agree to pay the whole betterment. The seller could have agreed to pay it. He could have just transferred that obligation, which is what he did, to the buyer, but it didn't prevent the property from being conveyed. And so that, again, that's the existence of the betterment was not something that frustrated the conveyance of the property.
So you're saying that taxes don't have to be included. They also don't stop a property from being conveyed.
I'm not saying that, but I think that in this situation, a betterment is distinguishable from taxes.
How?
Because the betterment, the taxes allow the municipality, as I understand it, to basically thwart the sale of the property if the taxes aren't paid by somebody. In this case, the betterment was subject to, it was basically a negotiating piece as part of the sale of the property. And so it was disclosed.
Wait, slow down a second.
Sure.
They can stop the sale by putting a lien on the property, you mean?
Right.
Can't they put a lien on for an unpaid betterment?
I'm going to be honest. I was looking into the betterments, and it's not clear how that works, but it looks like it can.
Do you know anything about, your brother says, opposing counsel says, there's a regulation or something that you're supposed to search title by owner name? Do you know, or they're indexed by owner name? Do you know anything about that?
I know nothing about that, and certainly not for the purposes of this particular statute. I could find no case that even discussed how the means of how the title search was to be done, other than saying that it was 50 years and it had to have the earliest instrument be a deed that was spatially adequate.
Counsel, for purposes of the appellant's claim, which you referenced earlier, is notice at all relevant as far as what they knew and when they knew it?
I don't know that notice is, there's nothing in the statute when we're talking about the statute that talks about it as being a means of creating notice. But I do think at its heart, the appellant's argument is one of reliance. And I think that, that their reliance being reasonable, if they're saying that they relied wholly on this certificate of title to advise them of a betterment, that they were already on notice of since the very first start of the transaction, I think that it fails for that purpose. I also think there's questions about the reliance in terms of the lack of any attorney-client relationship here.
But isn't that a question of fact? Because your client says he did tell them about the betterments and they say they didn't know about it. So isn't that a question of fact that does need to be resolved?
I don't think it is, Your Honor, because they acknowledge there's no dispute that it was in the listing, the betterment was disclosed to them. There's no dispute that it was disclosed as part of the counter offer that they accepted in the purchase of the house.
Well, wait. That only says subject to any. It doesn't say there is one. It says buyer to assume any and all supplemental water district tax and betterments. If
I
there
think
are
that was
any,
the
it just
language.
says if there are any, you assume them.
Sure, but I think that was the language. I think that was on the purchase and sale. but
Yeah, that's
in the
right. It's on the
outcome-
purchase and sale agreement. Surely that trumps whatever the MLS says.
Well, but the.
And the
well,
MLS
the-
doesn't mention, it does say outstanding, but it doesn't say 23 grand.
But well, the counter offer to purchase that they accepted also says assumption, refers to assumption of the betterment. And I think that whereas the terms of the purchase and sale certainly trump any earlier terms, I don't think that it's a reasonable argument to say that, oh, there was something that we can disregard the earlier knowledge we had about this betterment based on something that was ambiguous in the purchase and sale. And I also think that then that argument is separate from the duties that Attorney Murray had under the statute, which are outlined.
Okay, your time has expired unless there are further questions, and I'm happy to know. All right, thank you both very much. Excellent arguments, very interesting case. Never seen. I'm Justice Rubin, and I'm joined today by Justices Massing and D'Angelo. Due to some COVID illnesses, we are holding our argument today by video conference in order to avoid any risk to the advocates or the public. We appreciate counsel's assistance in organizing that, and also are grateful to the court staff for their work on arranging it. The final case we'll be hearing this morning is number 22-229. This is Maguire versus members of the Hamilton Planning Board and others. Our rules for oral argument are the same here as they are in person, which is to say 15 minutes per side and no rebuttal. And with that, we will hear first from Attorney Sheehan.
Good afternoon, Your Honor. May it please the court. The Shamsudins sought and obtained subdivision approval of their 9.5-acre parcel, which is now improved with a single-family dwelling, so as to create 3 lots. Each of those lots consists of portions of 2 parcels, so-called Parcel C and Lot 28. Parcel C enjoys the benefit of an express 50-foot wide easement. Lot 28 is after acquired property and does not enjoy that easement. It is for that reason that the planning board, in approving the plan, are required that all structures be built within the footprint of Parcel C. The procedure that was followed by the Shamsudins was dictated by the fact of the procedural history that years ago, their predecessor, not their immediate predecessor, but their predecessor, Nancy Terry, had sought to divide pretty much the same land. Lot 28 has gone through a few iterations that are not important here, but Nancy Terry sought to divide Parcel C and Lot 28.
Can I ask you a question? The Shamsudins currently own these 3 lots, lots 1, 2, and 3?
Yes, the Shamsudins own Parcel C and Lot 28.
Well, but what would be lots 1, 2, and 3?
And what would be lots 1, 2, and 3?
What difference does it make where the houses are built? Let's say they don't build houses on them at all. They own these lots, the subdivisions, no one ever builds anything, and they want to cross back and forth on this easement. And they go over to their property. This is how they go see it. They watch birds there or whatever. I don't know how developed it is, but they're bird watchers. They don't want to build a house. So they go over. Isn't the lot benefited by isn't each lot, or they sell the lots to 2 other people, 2 of them, and keep 1. Now there's 3 lots owned by bird watchers. They walk on the easement over to their lot to watch the birds. Isn't each lot benefited by the easement?
Well, Lot 28, the after acquired land, cannot be accessed
okay. All right. Cannot be accessed.
Right.
What does that mean exactly?
What that means in our view.
Yeah.
I'm sorry. What that means is that all of the activity that is to take place on these 3 lots must take place within the footprint of parcel C, because if we do not do that, if someone seeks to access lot 28 via the private way, then that, we agree, would constitute an overloading of the easement.
A small brush fire breaks out on lot 2 in the portion that was part of lot 28. There's some vegetation that grew. Maybe there's nothing there now, but 8 years from now, some vegetation grows. You can't stop it. There it is. Some of it dries in a small brush fire. You're saying the owners of lot 2 may not go to extinguish it.
What I'm saying is, in that situation, if the owners go on to, and of course they would seek to extinguish it,
I would
the
hope.
owners would do that, and in so doing, they would risk the claim that they have abused the easement, just as.
I guess they can't use the easement to get to the property, because a brush fire could break out at any time, right?
But I don't, well, with all due respect, yes, a brush fire could break out at any time, but with all due respect, Judge, I don't think the situation you've posited is any different from folks reacting to an emergency, a fire or some other type of emergency.
I'm sorry, I'm interrupt. I mean, I'm going to bring you back to his, what I think might have been a better question. Let's put the emergency aside, but the bird watching. So you are saying that the bird watcher owners would have to stop at the lot at the end of lot C with their binoculars, and they couldn't walk on to lot 28.
That is correct, Judge. Just like the folks who are using in the Taylor case, you will know the Taylor case, and the Taylor case talks of 2 separate easements and leading to various trails. And the court has said you cannot get from one set of trails to another set of trails without basically retracing your steps and making sure that you abide by easement law. We're not seeking.
So, but I mean, wow. So you're saying, so do you have any, I mean, you're saying that to put it in different terms that I'm familiar with, the use of lot 28 is to be entirely passive. The only use of that you're going to ever make of lot 28 is to meet the minimum lot requirements of 80,000 per lot, 80,000 square feet per lot. That's it. And so is there any case that says that in an easement situation, you can use the right of way to access property that's making passive use of property that isn't appurtenant?
Well, the Dellert case is a land court case on which we rely. And the Dellert case stands for the proposition that when land in a subdivision, in one subdivision, part of that land has the benefit of an easement, which is going to access the subdivision, and part of the land does not, that there must be a distinction maintained. And in the Dellert case talks of structures being built on so much of the land as enjoys the benefit of the easement. In fact, it was the Dellert language that was followed here by the Hamilton.
Is it divided by lots in that case? That is, do you have a case where when we talk about what land benefits from an easement, we don't talk about lots, we talk about particular square footage of those lots? I've seen lots of cases, because I looked, in which, and I understand these are just passing references, but lots of cases in which our court and the SJC says things like, lot 22 benefits from the easement. Lot 81 benefits from the easement. I haven't found a case that says the front 200 square yards or whatever of lot 22. It seems like it's just measured lot by lot. Do you have a case where something less than a lot has been held to benefit from an easement?
Yes, the Dellert case presents that situation, if Your Honor.
From an appellate court, do you have?
The only case that I have, Judge, that deals with this particular issue that you just answered is the Dellert case. The Dellert case was affirmed, albeit in a in an opinion that is prior to 2008, and so it's not properly considered, I guess, under the 128 rules. Nonetheless, it was affirmed. But other than that, I don't have an appellate case that talks of this issue. However, I would add quickly that we're not trying to do anything that is different. We're not trying to deviate in any way from the bright line rule that was set by Murphy, and it has been discussed by all the cases that have been cited by all the parties in this case. And we are not doing anything different with respect to trying to satisfy zoning than was done, as most recently described, in the Pinecroft case. And that is the recognition that there is a difference, an important difference, between so-called abstract use to satisfy zoning minimum areas, which is what we're doing here, and the bright line rule, which says you are to use that easement only for land which is benefited by that easement. And so that it is central to our position that we are acting consistent with all the various principles of law, that we limit access from the easement to parcel C. Now, the lower court was concerned about the phraseology, no structures. As I said earlier, the reason that the planning board used no structures, and it was at our suggestion, was so that it would be clear that we were seeking to come within the Dellert case. We acknowledged at oral argument, we'd acknowledged before this court that no structures means, in this case, no access. And so to the extent that that has to be made
unless there's a brush fire.
Well, Judge, at that point in time, what's going to happen is people are going to deign to violate the law, the civil law, maybe even the criminal law, not applied here, and would take care of an emergency.
What is the purpose of the dimensional requirements of the zoning law for building a house? Why does it require so many square feet?
That it all has to do with density. And what we're proposing to do here is absolutely consistent with the density requirements under the Hamilton zoning bylaw. It has to be 2 acres per lot. We're providing 3.5 acres per lot. And so we are absolutely consistent with the density requirements. And that is the purpose of zoning. Not only, Your Honor, are we consistent with the bright line rule, consistent with the zoning principles, we're also consistent with the goals of the subdivision control law, which is to make sure that a way provides for the safety and convenience of the public, and in particular for the neighbors. And we've done all of those things with the plan.
If you didn't have, let's just pretend there's lot 2. If it didn't have some of lot 28, it couldn't have a house on it, right?
I'm sorry, Judge, I didn't catch that.
If lot 2 did not have part of lot 28 in it, it couldn't have a house on it.
Right, under existing zoning, we would not have sufficient.
Why isn't the back part of the lot benefited by building a house? You need it.
Well, we want to make sure that we draw a distinction, Your Honor, between what the easement is, the use of the easement.
But to me, it seems like if someone walks along the easement and into the house to enjoy the house, and the house can't be there but for lot 28, that the easement is now benefiting lot 28 as well as lot C. Otherwise, it would be an undeveloped piece of property.
But the bright line rule talks about access, Your Honor, and this is the key piece, is that we have zoning issues, we have easement issues, we have subdivision control law issues. I'm going to ask this court not to confuse them, which I believe the lower court did, because the lower court got into this question and was concerned about, for example, the practicality of what we're talking about, which I would suggest is taken care of. The practicality of this is taken care of by the simple expedient of putting a fence.
How
along
far,
the property, along the line between parcel C and lot 28.
how far from that line is the house?
I don't know off the top of my head, Your Honor. I apologize.
Well, but is it right at the line, or, I mean,
No.
I assume dimensional, side, whatever, there are requirements about how far you can be from the sides and so on.
I know, Your Honor, that we
All right,
certainly,
I can look at the map. I don't want to.
we're certainly in compliance with all the setbacks.
Can I ask a question about 81W?
Yes.
Suppose we agreed with you that you could go ahead, but we agreed with Judge Speicher that you have to go back and do an 81W procedure, where you're going to only need consent for the hammerhead driveway, according to him. But what would that look like? What is? I mean, you argue that that's a form over substance thing, that the board implicitly modified the prior plan. But if you had to explicitly ask them to modify a prior plan, what would that look like?
The modification would be to remove the one lot condition that presently exists on the 1956 plan and the one lot condition that presently exists on the 1960 plan. And what we would do there, as Your Honor is aware from the brief, what we say here is that there was no consent required of the McKechnie's with regards to the hammerhead turn, because they lost no rights because they don't have the right to park in the middle of the easement. But before you get to that, I'm just wondering, as a matter of practice, like, does proceeding under 81W look anything different from what you actually did? No, not really. The form would be different. We'd have an 81W form. That's all that it would be.
Your time has expired, but I've taken a lot of it. So if either of my colleagues have further questions, I want to make sure they have time.
I just see what you were gonna on the use that the McKechnie's make of that piece of land for the turnaround. You say that they can't park there now. But it's not true. They're parked, I presume, because there's an easement, a right of way, but they're at the very end. If they park a car there, they're not going to get in the way of anybody's use of the right of way.
Well, to the extent that the right of way and our rights over the right of way run all the way to the end of the road. So our rights don't end at our property line. Our rights would extend all the way through. All of that said, there is a simple answer or solution to the issue here, and that is that if we were to go back to the land court, to the planning board, we could simply move that hammerhead turnaround 30 feet to the southwest or away from the McKechnie property, and so this issue that was raised and identified by Judge Speicher would be cured.
All right, your time has expired. Very interesting, almost metaphysical problem here. And we will hear now what Attorney Pasquarello has to say about it.
May it please the court. My name is Daniel Pasquarello. I represent the Maguires and the McKechnie's, who are the plaintiffs in the matter below and the appellees here, and also the cross appellants. Your Honors, the land court, Judge Speicher, correctly determined that the planning board exceeded its authority by approving the proposed subdivision, and its decision to annul that decision should be affirmed by this court. Before I get into the specifics, I just want to note a few quick background points here. First, there was no surprise to the Sham-Suddens that there could be no development of this particular piece of property. There had been restrictions placed upon it since the 1950s, and they were aware of that when they purchased the property. Second, there were multiple defects in the plan that was proposed by the Sham-Suddens, and the decision was rejected on multiple grounds. And we submit there are additional grounds that the lower court could have rejected that decision on. The key point here is that applicants' attempt to transform this private way into a subdivision road constitutes a per se overloading that violates the bright line rule. Thirdly, The plaintiffs have asserted a cross appeal here, but solely to preserve their rights. Your Honors, we submit that the board decision, should you affirm the annulment, that you don't need to reach the issues that we've raised in the cross appeal, but you obviously can do that if you like. And finally, by way of intro, the town here did not submit any appeal or make any appeal. As you focused on during Mr. Sheehan's presentation, the key issue here is overloading of this easement. There is no question that this is a violation of the bright line rule set forth in Murphy Mart and affirmed in Taylor. As the land court cited in its decision, it is a long established rule in the Commonwealth, as elsewhere, that after acquired property may not be added to the dominant estate without the express consent of the owner of the property. That bright line rule has recently been supported in decisions such as the land court's decision in Nelly versus Gray with Judge Foster, where he notes that a person should not be able to evade the bright line rule by the simple expedient of using an A&R plan to combine the parcel without easement rights and the parcel with the easement rights. And that's exactly what's going on here. I would like to address a couple of new arguments that have come up during the appeal. Mr. Sheehan just said that there's no intention to access any part of the back of the lots. That has never been presented before. Neither has the argument that there should be, I believe he's asking this court to say there must be an absolute prohibition against any use of the after acquired property, which is lot 28. That's new as well. I think that pops up in page 30 or 31 of their reply brief. But it is undisputed that you cannot create these subdivision lots without the addition of the after acquired property of lot 28.
Isn't it being used? Isn't the back of it being used by the owner of the property in order to allow him or her to build a house?
Yes, Your Honor, it is. Whether you call that passive use or active use or abstract use, it is still use. So there's no question that it's being used, and it certainly is being benefited by the easement, because the only purpose, the only reason to convert a private right of way into a subdivision road is to create frontage and access. And that frontage and access is created in particular for 2 of the 3 new lots. One of the lots would still have frontage and access on the public way, but these 2 new lots that only have frontage and only have access on the new subdivision road have to benefit from the easement. And you cannot create those 2 subdivision lots under Hamilton zoning without adding the land from lot 28. So there's no question that it's being used, and there's no question that it's for the benefit of the back lot. And I think Your Honor raised a good point that even if you build nothing here, you couldn't use the existing easement to cross parcel C to get to lot 28. That is a violation of a bright line rule. So they shouldn't be allowed to do it in the context of a subdivision. The other strange circumstance.
Can I ask you something?
Yes.
A few times you've said they're trying to change a private way into a subdivision road. What is the significance of that terminology?
Right. So it goes to the fact that 2 of the lots, actually 2 of the new lots require frontage and access on that subdivision road, Your Honor. So they have to use the easement to get to the property. It's not the same for parcel C right now. Does not need to use the private way for access or frontage because it fronts on Meyer Road, which is a public way. So
you need to call it, so you can't satisfy frontage with a private way?
Well, a subdivision road can be a private way, Your Honor, but a private way is not necessarily a subdivision road. So in this case, for the purposes of the definitive plan, they have to have frontage somewhere. And 2 of these new lots have to have frontage on this subdivision roadway.
Right, but it doesn't make a difference if you call them a subdivision road or a private way. What is it illegal?
Your Honor, yeah, I draw that point out because it goes to the reasonableness of what's being asked here, which goes to some of the other arguments we are making. I don't think it necessarily the terminology is necessary for our point to prevail here. But we also
have a separate legal argument. It's more like a,
It's not, well, it goes to the reasonableness argument in the cross appeal, Your Honor,
But
as to
it
whether.
does it become a subdivision road because it's on a subdivision map, or are you saying they're paving it and turning it into a road, not dirt? Or what does that phrase subdivision road mean? Is that a legal conclusion?
Well, it is, Your Honor. It's in the context of the request for approval of the definitive subdivision plan. So it becomes the frontage and access for two of the lots. That's the reason why I'm saying it's the subdivision.
Yeah, but I don't, if they don't improve it at all, assuming there's no fire department objection, could they leave it looking exactly like it is, but it would still be called a subdivision road in your view, once the subdivision plan is approved?
No, well, Your Honor, you can't approve the subdivision plan without improving this roadway to bring it up to the subdivision regulation standards. So that is, you may have noticed in the back of our brief where we talk about reasonableness, and we say the plaintiffs don't think this is reasonable because they don't want a sea of pavement poured in front of, their two houses, which for the past 70 years have been on a narrow private drive. So that's really where we get to when we talk about conversion into a subdivision roadway. But again, what's key here is you have to use area from lot 28 to create those two new lots. So you're obviously benefiting those back two lots. And we think that Judge Speicher got this right. It was a well-reasoned decision with respect to the bright line rule. And I would also like to say that to address the argument that the plaintiffs can somehow solve this problem by limiting their construction to the footprint, or the Dellert argument that they're making, which is, first of all, it's not a controlling case. Secondly, Judge Speicher did distinguish it. Third, it doesn't involve a subdivision like we're dealing with here. It's a different set of facts. And in this case, I think in Dellert, they were talking about, well, you could build out in accordance with what the West Boylston or West Hampton zoning bylaw said you could do. You can't do that in this case. You cannot build by right on parcel C because it's only 2 acres and you need 80,000 square feet for each of the lots. So in effect, what you have here with respect to zoning is you're going to shoehorn a cluster of 3 residences into a 2-acre parcel, which it's really supposed to be a 6-acre parcel here. And the newly proposed solution that we have some kind of absolute prohibition on any use of the back portion of these lots is just not realistic. And Judge Speicher addressed this as well. He said, for one thing, that would violate the bright line rule. So, I mean, the difference we have here is we also have the bright line rule. And if I may address the Pinecroft decision that was just raised, which is a different animal than what we're dealing with here. As you know, Justice Massing, since it's your decision, that was a split lot zoning case, and that's a very specialized area of the law. And even in that case, well, what's different here, nobody's disputing that the passive or abstract use is still use. So here, there is still use, and I believe the question in that case is whether the zoning bylaw was properly interpreted, whether the expansion zone for the more restricted lot could go back. That's not what we're dealing with here. As I said,
it's not an easement case. It's not an easement. Can I ask you about 81W? Like,
Yes.
For you, it's very important that they go through the 81W procedure. How do you respond to the argument that that's really just a different, it's just a matter of filing a different form? It really is form over substance.
It's not form over substance, Your Honor, because it's a statutory requirement. And the Samuelson case, which we cite in our brief, is on all fours with this. You still have to go through the procedure. And I can understand why the applicants didn't want to go through the procedure because they could avoid the consent requirement. But here, they're required to get consent. That's why it's important to obey what the procedural requirements here. Nothing in the Terry decision prevented the applicants from seeking modification as well as presenting a new plan, which is what I submit they should have done. They should have requested modification and submitted a new plan here. There's nothing in the application that seeks modification. There's nothing in the decision that addresses modification. There's no discussion of modification at all. They just blow right by it. But again, Judge Spicer got this right, that consent from the McKechnie's was required on this.
So, I mean, in your cross appeal, you argue that their consent was required for much more than that as well. I mean, so are you basically, I mean, your argument is that even if they could do this as a matter of easement, you'd still have to, they would still require your consent to have two dwellings instead of one.
Well, so we agree with the land court that consent was required due to the parking deprivation issue.
But you also contend that you have a veto over the number of houses.
Well, yes, Your Honor. I think that the McKechnie's consent was required in a broader circumstance here. And if you are to get to any of the issues in our cross appeal, this may be one that you want to consider because it addresses the Patel case, which I think has become a bit of a sacred cow where there are very few cases that are deviated from this. What we're saying is under Matthews, this situation is very similar to the Matthews case where you had notes that were adopted by the planning board. Same thing here, that the owners were entitled to rely on. So that's the same situation with the McKechnie's. And if you go back further, I mean, Patel talks about what efforts did you take either through private land use controls or covenants or notes or something like that. In this case, those measures were followed. At the time that the planning board adopted the restrictions in the 1950s, there were deed restrictions in place that limited development to just one residence per 2-acre lot. And that's important because at the time that the easement was created and at the time that parcel C was conveyed, parcel C was created as a 2-acre lot. So there could not, everybody knew there could not be further development of parcel C at that time. So in this case, those instruments were in place. And also, and this ties into the overburdening when you're talking about 81W with Patel, but I do think this is a case that affects title under Patel, because if you allow these 2 new lots to be created, you are in effect creating 2 new easements for the benefit of lot 28. There's no easement for the benefit of lot 28 now, but because the 2 new subdivision lots are required to use land from lot 28, if you give them an easement, you're now opening up an easement to a lot that nobody contemplated giving access to at the time that the easement was created. I think I addressed all of the 81W questions. If you have others, I'd be happy to address those as well. But we do think that consent is required here from the McKechnie's. We think that the court could have gone further. It didn't, as we've said, it didn't need to go further because it still annulled the decision. However, I would like to address the parking issue. The parking deprivation is beyond just the turnaround here. There is actually a prohibition of parking in the entirety of the way now, based on how the decision was written, because it must be kept clear and passable. There's undisputed testimony from both sets of the plaintiffs that they do park in the way. And the only reason that they're being prohibited from doing that is because it's now being converted into a subdivision roadway, as we talked about. And now you have to, for the benefit of the applicants, keep this clear. So preventing a homeowner from parking on their property, I do think is impermissible, and it exceeded the authority of the planning board. And with that, Your Honor, as my time is expiring, I'd be happy to rest on my briefs.
Thank you very much. Your time is in fact expired, although again, if there are further questions from either of my colleagues, I'm happy to.
I completely understand everything, so.
Outstanding. Me too. Fascinating case, very well argued from both sides, very interesting and complex questions it raises, and it is submitted. Thank you very much for your assistance to us through your arguments. And with that, our sitting for